Welcome to the Foul Play YouTube channel.
Hello, everyone. Thanks for joining us on a Sunday for today's, number 12 episode of the Open Mic. We've got several interesting subjects to cover today. A little bit complicated, but, what isn't in this case, right? We're going to be talking about surveillance video. We're going to be talking about FOIAs and how to write them. Hopefully, at least a few people have found that instructional that may want to write a FOIA, but just didn't know how, or maybe a little tentative about doing it. So, but we have a lot of the FOIA warriors out there in the world that have they brought us so much information that we just didn't have, and that began literally within probably a month of Making a Murderer getting released, because we literally had a few newspaper clippings and videos that we could find from the news stations. We just had very little to go on. So anyway, before we roll with that, I would like to get a few updates. Then hopefully I'm not putting Alice on the spot here, but we have we're still really going after the Luke Mitchell and Jody Jones case, and just if Alice could give us like a quick update or kind of where we're at, what she's things that she may have heard. It doesn't have to be anything too in depth. I did watch at least part of Dr. Sandra Lean's video today, her update, and it was interesting. But Alice, why don't you tell us what you know just since we last talked?
Not much. I've just got the book, so I've just started the book.
What do you think about the
book? Innocence Betrayed. It was the only way that Sandra could put down the information that she's got legal-wise. So she's put it into a book, and it's all been taken from documents, because she's got access to all the documents and everything like that from the defence and things. So the information that she's got is from the case itself. And just as I said, I've just started, so I've not got quite into it. But what I've read so far, we've already covered a lot of, but it's just going on about the changing in statements and the other people that could have been put up as potential suspects in a sense, but never got looked at, and how much close tunnel vision that is going to be on Luke. And you can see that straight from the off, that they were set on Luke and nobody else. So as I say, I'm still learning myself, but it's good that Sandra does an update every Sunday, 4 p.m. UK time, and she has a load of questions that she's went over through chats and all the different sources like Facebook and things, and she gets a load of questions and she tries to answer the questions
right
as best she can, without giving anything away. And if she can't answer it, she will say, well, I can't give out that information, or I don't know that information. But she does it every Sunday at 4 p.m. UK time, and she just gives us an update on things. And today, again, it was just answering questions.
I did notice, if I could interrupt you for just a second, I did notice that she was really having to re-answer, and this is kind of like a rinse and repeat. Apparently, there are rumors out there flying wild about various things that are just simply not true at all, and she's having to clarify and re-clarify, and it's really, I could tell she's irritated with it. It's really because
I mean, it's not.
Go ahead.
Well, it's not even just that, Jack. It's the whole thing of, if Sandra says one thing, say Sandra says, and this is just an example. Sandra says that something happened I don't know, 7:15 in 29 seconds. But then Corinne says, oh, it was round about 7:30-ish. Then they pick up on that and they say, oh, well, you said one time, but you're saying one thing and Corinne's saying something else, you know, and there's a lot of people that are just nitpicking at things like that. So that's why she has to go on a lot of the time and say, you know, the times that I'm saying, and the reason why I'm giving it to the point in the seconds is because I've seen the transcripts and things like that. So, but when Corinne's talking about it, it's just a time that she's saying she can't remember exactly whether it was 7:15 and 49 seconds or no. She just knows it was somewhere between 7 and 7:30. So that's why she would say it's 7:30ish, you know, and there's a lot of that going on, but there's been a lot of that going on at the beginning as well. There's still a lot of people out there that believe Luke is 100% guilty. They're entitled to their own opinion,
right?
And that's fair enough. But you've also got to look at it for the other side as well. You know, you've got to have an open mind. You've got to go and get the book. I would advise anybody to get the book if they can. Watch Sandra's videos. Sharon Sunshine does chats on it as well. Go and watch these things because these people are getting it first hand for Sandra herself by reading the book and things like that, you know. But as I said, there is a lot of people that still believe Luke is 100% guilty, and there's ones that now coming forward and saying to Sandra, oh, well, I thought he was guilty because of the media coverage and everything like that, but now my mind's starting to change, you know what I mean? And that's what we want. We want people to don't just take the documentary, don't just take the newspaper articles that was back then as well. Go and get the book, look into the stuff that's online about the case, about his appeals and things like that, and learn more about it. Just like we've all done with the Stephen and Brendan case. You know, a lot of people say we were duped by a documentary. No, we've looked, we've researched, we've done the transcripts, we've read the court documents. You know, we've been through it tooth and nail, and that's how we get our information. The best advice I can do to anybody is get Innocence Betrayed by Dr. Sandra Lean, and I'm sure it's innocencebetrayed at gmail.com, where you can buy it directly for Sandra herself, and just learn about the story, and I swear it will open your eyes, and it will definitely open your eyes a bit more to the UK justice system. Now, I thought we were a good system, and you've heard me saying it plenty of times. But I'm getting slapped in the face, left, right, and centre with reading this book and reading the things that I'm reading, and I'm actually shocked to say that. But I'm learning, and I'm looking at it with an open mind, and that's all I can say for anybody else, really.
Well, appreciate that. I mean, I did, take it from, just watching and listening. I didn't get to watch it all, but I did have it on in the background, just listening to her, having to correct, and, misinformation is really difficult to undo. I've seen it happen in these two cases that we're after, Stephen and Brendan. Misinformation can be a killer, and it's really, really difficult to get it stopped. I know yours is well aware of that. He's seen it as well.
No comment.
Yeah.
So,
I mean, it was another trial by media scenario. It was the papers that put his name out there. It's the papers that's having the headlines, the spawn of Satan and everything like that for a 14-year-old child, just because he looked different and he had a different taste in music, and they twisted it, and I mean, they even twisted things about him and his mum's relationship, for crying out loud, and a lot of people at the time took what the newspapers and that were saying as gospel, and it's only now, since the documentary and
people are questioning
the groups online and that you can ask the questions, but what about this and what about that and what about this? and they've got somebody there that can actually say, well, that was actually the papers that said that. That was actually the polis said that. That was actually the rumours that was going about the area at the time. You know?
Right. It's crazy. It's a crazy case. Well, I appreciate that, Alice. Everybody, I mean, we're going to stay after this case. We're going to stay in it and go as far as we can. Dr. Lean is scheduled to join us next week, and we'll have a lot of information available as to time and so forth. But appreciate that, Alice. Let's move on to Becca and Linda checking convictions about their progress with. I know they're reading the Avery appeal Dassey appeal docs from 2010, I think, and I did get to listen to some of it. I didn't have time to listen to all of it, but I did listen today, and some really good information. And I know for a lot of people it's rehashed, but I don't care. It needs to be rehashed. You can't let it go. You can't let it stop. So anything else planned besides that? Either one of you can answer, Becca or Linda, or both.
Nope, just plan on doing that, I guess. I don't know, Becca, what do you think?
Sorry, I was muted. But basically, we're just working on that, the post-conviction stuff, and going over that kind of stuff. And we might be going over, we just ended Brendan's interview with Wiegert and Fassbender at the school. So I think we might be going over Wiegert and Fassbender's interview with Barb. That was after that. But yeah, no, just hitting up the post-conviction stuff. And so far, that's the only plans, other than getting people to subscribe to our channel. That's
excellent.
About it.
That's right. Everybody get over to Becca's channel and subscribe. She needs members, so she's gonna try to stream live during the rally this year. So she needs 1,000 members. So get your butt over there and subscribe. Help her out. The next thing I guess is really on the plate. I guess before we move forward, because what I'm going to get into it's kind of complicated, and like it is complicated. I'm just going to say that it is complicated, and going into this subject that I'm going to talk about first is the surveillance video that we first saw it when Ken Kratz released sacrificial lamb video in October of 2019 as part of his. I'm sure it was I think he was promoting his book because he had added a couple of chapters to his book that Dr. Silkman has been reading on Saturdays, reading with Uncle Ken. So he was trying to get people to look at it and of course buy it. And he released this video. I'm not going to play it. It is available. You can find it. Is out there. Someone did grab that video, and it's in their channel. But I'm not going to play that video because some of that actual footage appeared in Making Murder, and I don't want us to get even close to a copyright infringement or a strike. So, but the video is available. He did, I don't know why he did what he did entirely. BB, you want to comment on that while I pull up this video? Why he would release?
Yeah, I seriously believe he thought they were going to throw him under the bus. So he released it as a, take this, if you throw me under the bus, I'm going to take you down with me. And I believe it got pulled right away because they told him back, the powers that be, you take that down now. And then he suddenly disappeared not long after that. So
he did within days. He yanked it down and he burned his Twitter account. I'm not sure what Facebook accounts he may have. I never followed him there. Yeah. Never will, and never will. But this video that I'm going to play, it has no sound, so no one has to mute. And if you want to comment during it, that's fine too. It's a 5-minute video. I'm not going to play it all, but I'm going to point something out to everyone that I really didn't notice until I was looking at it last night. I don't know why I didn't notice it. I guess because there's really no sound to this video. So it just got by me. But anyway, we'll play a little bit of this and we can talk as we're doing it. obviously this video, and I'll kind of explain as we go along. This video was taken approximately March 17th, I believe, but it was around the 15th when the jury was in deliberations. Buting had went to the jail to talk to Avery, and he had taken a camera with him to the CASO jail. And people have to understand that there are policies and procedures surrounding, all jails when you go in to visit someone. Where they're at right now is called a contact visit room. Now, if you don't go into a contact visit room, you're forced to sit at a phone through barrier and talk. And those are recorded. They tell you they're recorded. There are sounds everywhere. And if I'm remembering correctly, the visits are generally cut pretty short. They don't allow you, I think, more than like 20 or 30 minutes total for family and friends to come talk. And you must be on the list or they won't let you in. So anyway, Buting had went to talk to Avery during the deliberations and found out, how he was feeling. Anyone that wants to see this video of actually what Avery said to Buting can see it on Making a Murderer because he talks in there. And there was the way Avery answered it, because I just watched this a few nights ago. He was really, you could tell he was really like, I don't know what's going on. He was searching to reply. So anyway, at some point here, this is clearly not the entire video that was recorded on the security, or I'm going to call it surveillance video, because we're going to get into a little bit more about who knew what, because there are questions surrounding this. But nonetheless, this video camera was hidden. It was not out in the open. No way. So Buting takes out a camera. He records Stephen. They talk and so forth and so on. It's unclear how they talked. If you look at the video that Kratz posted, there's a counter in the lower left-hand side of the viewfinder, and you can see it's at least up to about 16 or 17 minutes. So when the guards came in, I guess they saw this in their monitoring capacity of watching this unfold in this privacy room. We're going to get more into that too, what that really means, this contact visit room. They came in apparently, and I guess they called. I guess they called Pagel. I don't really know. I don't remember. But regardless, I guess they came in and told me couldn't do that. And I don't know if they took the camera, but if they did, according to the video that you can see that Kratz posted, there's at least 15 or 16 minutes recorded. You can see it in the lower left-hand corner. Now, does that mean anything? I don't know. I really don't know. So anyway, I'm going to pop this forward just a little bit. Where was that at? I think it was more towards up this direction here. I want everybody to watch this lower right-hand corner behind Buting. Because you see that? Everybody see that? It's going to come through here in a minute. There's definitely some movement back there, and I'm not really sure what it is. I'm sorry, there's a little delay between me talking and you seeing it, but it's definitely there. And I asked around last night to find out if someone was with Buting, and the best I could find out was no, he wasn't there. No, or he was there alone. And there are there's more documentation we'll talk about here shortly to explain my position, why I feel this way. One more thing before I drop this one out. I definitely feel like that there is sound associated with this video. I can't prove it, but we, even enough, I found out, and I know many people here and watching, they know how easy it is to strip away an audio signal. It's just not hard. And so, you're left with just a video. So can't prove it, but why would whoever installed these surveillance cameras in these privacy rooms, contact visit rooms, go to the trouble of installing a camera without sound? I'm sorry. I just, my personal belief, I'm not trying to force my belief on anyone, but it's my belief that they were indeed recorded, audio and video, and these were, used in whatever capacity.
It would be hard for me to believe that there's no audio with that.
If they're going to break the law to put a video camera in there, you know damn well they're going to break the law and fully break it and put audio in there as well.
Well,
I'm just out of curiosity. Ken Kratz used this video. He had audio, didn't he?
not from
Or
not
am
from
I
here.
confusing?
There was audio.
Okay.
There was audio on his YouTube video, but there was no audio from the jail video. No.
But we have because this is when Jerry Beauty was recording Stephen for an interview in right?
That's right.
So we have audio from that we could, play at the same time in a way, right?
Well, that audio that is part of making a murder. That's why I said I'm not going to show it because I don't want to. I don't want to get near.
But I mean, like in theory though, you could play that audio and then that should reflect and plus, you wouldn't see behind Jerry. Okay.
No, and I don't know what that movement is.
It's a ghost. I'm just putting that out there.
Well, I don't know. I may need to talk to. I don't know. I asked around and
I think was there no other? There was a video somewhere because it shows you. Or am I getting that from Mama? It shows you Stephen in a wee box.
Yeah, that's Kratz video. That's Kratz video.
Yeah, and for the wee box, and they saying this is what was left out of Mum and that. But that you've just shown, that is maybe one of these snake cameras, which you don't need a very big hole for, so they could puncture a hole through the wall, put one of them in, and there you go. They're watching and listening to everything that's being said.
Right.
That's possible. A scope camera. That could be a scope camera.
Well, and Linda says Seeking has a slightly different one of it, and if there was a number counter,
no, this is the one. This is the one from Seeking's page.
If there was a number counter
audio,
in that,
right?
Yeah.
I'm sorry. What?
It's without audio, right?
Right. There's no audio.
Right. That's what I meant. That's what I meant when I was saying that. It's slightly different than the one that everybody sees in MAM. Because there's audio.
No. What Kratz did, he took that video that we see, what I just showed you, and he overlaid other things on top of it.
Oh.
It's the same video. He took, again, I don't know where how they got, the footage off of Jerry Beauting's camera and inserted it, but they did. So did they take it and make a copy? I don't know. And I don't want to go too far into speculating and accusing him of the jail of doing that, but I don't know how they got it. Because go ahead, BB.
If there was a number count going in the bottom right-hand corner, they could have blacked that out, and that could be what we're seeing. As the numbers got bigger, they needed a bigger spot to black out.
It's not blacked out. You can see it on the video that Kratz made. The counter, the time is rolling. You can see it clearly.
The black thing there in the video we were just looking at?
No, because the counter that it's in the Kratz video is on the left-hand side. That looked like an arm to me, or
a knee,
or something. It looked like a body.
Yeah, it
moving.
looked like a person. Yeah, it looked like a person. Yeah.
So I got to ask what the hell it was. So it just so we're clear here, and I'm going to talk about FOIAs later, but because of all these questions surrounding it, there was a lot of discussion this past week on Reddit in the MAM sub community about this surveillance video and what it means and what it could potentially mean. And there's this is not the first time this is blowed up, and I'm sure it won't be the last time because my personal feeling is it's a direct violation of the 6th and 14th Amendment. You don't record a lawyer and a defendant having a conversation. You just don't do it. And beyond, and we'll get a little bit more into this here in a few minutes, but beyond a lawyer coming in, what if a priest came in and says, you want me to take your confession? and this mass murderer decides he's going to unburden himself on to his priest, and he just spills his damn guts about the 50 people he just killed, and they captured it on video. Now, I'm not saying that guy shouldn't be punished at all. That's not it. However, is it right for the police? They got whoever jailed. They jacked up Avery's bond to $750,000. He couldn't get out. He's stuck there. So to me, this comes across as the state saying, we've got you by the nuts. You can't get out. And the only way that you can have a private conversation is with us recording you. And I'm sorry. I'll fight that till I die. It just grounds me sideways to think about someone not being able to make bail. The system is either set in place and due process is followed, or it's not. And in this case, in my opinion, go ahead, Sammy.
Go ahead.
No, go ahead, Sam.
Well, by all rights, it appears as though he wasn't allowed any private conversations at any point in time ever.
That's exactly right.
Not for real.
That's exactly right. Because, I come to find out, I thought there were 4 privacy rooms. It turns out there's only 2. But, if they put recording devices in, each of these rooms, now it would appear, the information I got, it would appear that when the lawyers went to visit with Avery, they were always directed to this specific contact visit room. I can't say that for a fact because I don't know it, but that's the way it appears. So this becomes a real problem for me. No matter, if we think about, somebody's guilty, somebody's not guilty. That has nothing to do with the state recording someone for their own purposes, to watch and listen. And people are saying, well, it was just for monitoring. It's just for security. Well, the doors there are windowed, and I have a suspicion that area behind Beauty that there was another door. I'm almost positive that both or the 3 reporters that they talked to in this, I'm going to bring up the motion here in a few minutes. They talked about it being windowed, but the blinds were drawn, but the doors, there were officers stationed at each end. So they would have had a clear view of anything going on inside that contact room without having to be recorded for posterity or for, 3 or 4 freaking prosecutors to watch later and say, aha, we got this and we got this. Let's pursue it from this angle over here. It brings up a lot of problems for me, simply from the fact that they had Avery hung and they weren't going to let him out. And he couldn't have a private conversation with his lawyer. This goes against it. I'm not a lawyer. I'm sure there are all the lawyers out there that are rolling their eyes at a lot of us. But again, a lot of them aren't. The ones that I've talked to said, no, it's not right. A lawyer and a client are allowed to have a private conversation. So anyway.
Jack.
Yep. Yes.
Do we actually have a time frame when when Beauty spoke to Stephen? Do we know when that occurred?
This was from what I'm pretty sure it was March 17th, 2007, about 1 or 2 days after deliberations began.
Right. So this would have been pre-trial. Is that correct?
No. This was during jury deliberations.
Oh, during the jury deliberations.
Correct.
Okay. So what? I was going to say, what advantages would it have been to the state to record Stephen at that stage?
Well, here it wouldn't, but if the camera's there.
Oh, okay.
Because you're going to see more information coming up that's going to direct you right back to this camera from at least a year and at least 8 months prior to this. So
right. So the point, I suppose the point is, when did they start recording Stephen?
And that's a great question.
One.
That's a great question because, as many of you know here, and I'll reveal it to everyone else that's listening. Like last week it was suggested to me, hey, why don't you try to find out when these cameras were installed? Huh, okay, great idea. So I rattled off a FOIA to Calumet County Sheriff's Department. And to their credit, they got back to me very quickly. I got an automated reply first. And then the very next day, I believe it was on Thursday night or Friday night, I got a reply from an official there. I'm not going to reveal the name because it didn't matter. But they've been there a long time. They were there during this time frame, the way back when, replied that their financial records don't go back that far. I requested the receipts for when the cameras were bought, what kind of cameras. I wanted the work orders for installing them, including electrical, the monitors, the recording, what kind of recording equipment. I wanted everything. But they said their financial records do not go back that far. It's beyond their, and they're, for most entities, people have to understand they only keep these places only keep records for a certain amount of time, and they have regulation in place that they're allowed to dump it, get rid of it, because it's
right. Well, the interesting thing here, apart from the fact that they are illegally recording Stephen and Buting, but the thing is that Ken Kratz made it very clear in his book that they were listening into all his phone calls, right? All his jail phone calls.
That's right.
They were listening into the calls that he did with Jody. So it seems to me that this could well have been a strategy by the state from day one. It'll be interesting to see whether Ken Kratz is actually using that as a form of ammunition, against being thrown under the bus, like you said.
Well, I think that BB may be right that he's saying, look, I've got a couple of things up here in my filing cabinet in the sock drawer. Leave me alone. Quit bothering me. You're not going to throw me under the bus, because if I go, you're coming with me.
Right, but
did one of the officers say on oath in the stand that there was no cameras in the rooms?
Yeah, we're going to get to that. That's a good point. We're going to get to that. Before
they lied. Oh my God, they lied.
I know. Oh my God.
Shocking, right, Doc? I can't believe that they fibbed.
Well,
how dare they?
What I find interesting here is, where did Ken Kratz get the footage from? Who gave him the footage?
That brings up
probably
another.
Had it.
That brings up another point. So, unless there's more questions, why don't we move forward? Because we got several documents to go through, and I'm not going to go through every single document, but there is one part of this I'm going to have to read at least a good chunk of it, because if I don't, there's a less understanding of what really happens, and it's important to understand how the jail operates and how they do business. So I apologize for that, but let's get through this right here, this part right here. So can everyone? It looks like it's not blowed up real big, and I can make it bigger if need be. Do I need to make it bigger for everyone to see? I can, but this basically, I'm not going to go through all this document per se. I did take excerpts out of this that will be easier. So let me just explain this, and then we'll move forward. In 2013, February 14, 2013, as you can see at the top there, Avery filed a pro se motion. And he covered more than one thing, but part of the what he covered was being surveilled. Okay, so he, like I said, he there's some other things in here, so that's the reason I'm not going to go through. It's 41 pages. I'm not going to go through all of it, but the photos I've got, let me pull it up here so you guys can see, or these snips I took out of this motion. It's going to show what I'm talking about. Let me pull this and the close that. Here we go. It's going to pop in there.
Asking, would the company who installed them possibly still have those records? If so, would they be allowed to give them?
Well, see,
that's a good question.
I don't know. We don't have any idea where the order came from. Now, as far as I'm concerned, and we'll see later, John Byrne was the jail administrator at the time. He'd been with the CASO, I think, for 27 years. But at that time, he was the jail administrator. And you'll see later in the testimony, pretrial, he's like, there's no cameras, there's no recording devices back there. So the only person, in my opinion, that could have ordered it would have been Sheriff Poggle. So that means either.
Well, we do know that over there, the LE has access to people who wear many hats.
Yep.
Who's to say that this was actually on a level?
See, and that's why I also asked for any county employees that may have installed these video cameras, but they said they don't. Those records don't go back that far, and I can't force the issue because I can't prove it that they do. So anyway, this pro se motion. This is page 2. While being housed in the Calumet County Jail, Avery met with his attorneys and his private investigator. The jail engaged in active monitoring of his conversations with his attorneys and his investigator. See exhibits 1, 2, and 3. And I'm going to pull them up here in a minute because they're attached in this. By the way, this pro se motion and all this other, many of these other exhibits I'm going to show was FOIA'd by Seeking Truth. And I can't thank her enough. Just hats off. I'm in awe of her machine-like FOIAing and getting information. Anyway, monitoring his conversation with attorney's investigator, see exhibits 1, 2, 3. His attorneys never challenged the information provided them in exhibit 1. However, Avery only found out about the monitoring by 4 jail workers through an open records request after his conviction was final. Okay, so let's go back here just for a moment. And I'll open this up. Let me open that back up. Let that open up. There it is. Okay. So let me open up this other tab here. I apologize. I got a lot of tabs to show everyone so we can explain. That's going to pop in here in a minute. And this is exhibit 1 that he just mentioned. And this exhibit was written by Pete Batts, the investigator. And in this, I want you guys to remember this date. This was written on July 20th, 2006. Interview with Stephen Avery. Pursuant to a request from Mr. Avery, I traveled to Calumet County Jail. This date, arriving at approximately 11 a.m. Mr. Strang had contacted the jail and advised them I was coming. Jail staff met me and requested identification, which I supplied via Wisconsin's driver's license. The jail officer took his driver's license and returned a short time later and advised that jail administrator wanted to know if I was a licensed private detective. I advised that I was not, but I was meeting with Mr. Avery at the direction of and as an employee of Mr. Strang, attorney for Mr. Avery. The jail officer then advised that I would be required to interview Mr. Avery in the visitor's room via phone and then showed me to the visitor's room. The phones are clearly marked that all conversations are recorded, as I mentioned a minute ago. At that time, the jail officer asked how long the interview would take, and I advised that it would be less than 5 minutes since I could not discuss anything over a recorded line and in those security conditions. The jail officer, a very large man in uniform, left, but returned a short time later and took me to the interview room, which was the same room where I had previously interviewed Mr. Avery while in the company of Mr. Strang and Mr. Buting. This is important. As the jail officer was exiting, he turned and stated, "You know everything in here is recorded, so anything you said is at your own peril." The hell have we heard that before? Mr. Avery was brought to the room, and I advised him what the jail officer said regarding recording. I advised Mr. Avery that it was under the circumstances he should not say anything to me about the case. He acknowledged that and said that he just wanted to tell me to check out Scott, his sister's boyfriend. I stated that I would relay that to Mr. Strang and Mr. Buting, and then suggested that we continue our conversation on how he was doing in the jail, how the food was, etc. The remainder of the conversations were merely involved those subjects. During the conversations, I examined the room and could not locate any overt signs, overt equipment, signs, or any indication or warning that the events in the room were being recorded. Since the jail officer appeared to be candid and honest in his advice that a recording was being made, I can only conclude that any such action was done covertly and absent a direct notification such as a made to me will occur without knowledge or consent of the room's occupants. Conrad Betts. Comments? Questions? I'll let that soak in a minute.
Well, I just have always felt like if this was done, it's been sneakily done. It was not on the up and up. That's all I got to say. As far as they're being installed, I don't think there's ever going to be a record found of a proper installation of such devices.
That's for sure. A couple people perjured themselves in court.
Well,
Yeah. I mean, that officer saying in court that there was no cameras in that room. The direction that camera is facing, if that was in the corner of that roof between the roof and the wall, Jerry would have seen it if it was a proper security camera.
Sure.
Which, in all fairness, I reckon that he would get it be switched off with him having the client lawyer privilege sort of thing if there was a camera in that room. So, of course, that's been done covertly.
Jack, can I make a comment?
Absolutely.
Yeah, often what they do is they hide the camera within a smoke detector. So
absolutely,
if you were looking on the roof, you wouldn't see a video camera. Often what they do is they hide it either within a smoke detector or a passive infrared detector, like, for example, like an alarm or a security system. So if you're looking around the room, you go, oh yeah, that's just a normal detector, or that's a smoke detector. So to me, the jailer admitting that it's been recorded, that's huge. That's a huge point.
It is. And, and then Avery saying, like, that first slide I had up there, that he wasn't made aware until after, everything was said and done. However, this memo, Exhibit 1 I just read, I'm sure that, Buting and Strang were aware of it. However, at the same time, that being said, he didn't have any proof. Now, he did say that the guy said, like, he was candid, but again, that's not necessarily proof. And, I don't know what, if any, steps that, Buting and Strang took to dig this out and find out what was going on. I think it's a huge injustice. It's terrible to me. But anyway, go ahead.
I was going to say, not only that, if the authorities have been made aware that there has been a leak of information, all they simply do is remove the device from the room, and there's no evidence at all that it was ever there, except for the fact that there is a recording. So that's damning in itself.
It is to me. It's really damning. I just don't know how you can get past the fact that this is beyond monitoring and saying, well, we're just going to keep the guards safe and, a lawyer safe or whatever. It's beyond that because you memorialize it. It's not a passing of just watching something happen. You've taken and recorded so it can be watched later. So
yes, for me, Jack, it begs the question: why did Ken Kratz release it? And I agree with BB. I think it is an insurance policy. To me, it's exactly like Culhane writing down what Fassbender said to her. Try to put her in the garage and the trailer. That's a form of insurance, i.e., oh my God, what else have you got?
That's exactly right.
That's how Ken Kratz works.
Well, go ahead.
And let's face it, he's not only being recorded on his phone calls, and now he's being recorded in the privacy rooms, but he's also got jailhouse snitches turning in. So he can't say a fucking word in that jail without somebody memorializing it.
That's right. And that's a huge problem for me. I don't care who the defendant is. I mean, none of us want any bad. We don't want any bad guys out there.
If he talked in his sleep, who's not to say there's cameras in his cell recording what he says in his fucking sleep, too?
I wouldn't doubt it. T1 is asking, he says, I wonder if there's an interview room scheduling sheet that exists.
Probably. Whether they would still have it, I don't know. I know that, no one could. You had to be on the list. George, you could probably answer that.
Well, I was thinking something else because, they were going as far as planting evidence. I mean, they crossed that boundary as well, And we are here talking about whether or not they, use that footage. They surely use that footage against him, They crossed that boundary as well. If they're willing to cross that boundary to plant evidence, they'll do anything to listen to him from day one about every move he made.
I agree, and try to take anything that he may say and manipulate it. Right?
Get Steve Avery at all costs.
Yeah. They would know everything. They would know if he farted to the left on that day one and he farted to the right today two. They would know the difference.
That's right.
Everything.
Exactly.
Yeah.
So
you've got to remember in the beginning as well. The phone calls that he was getting for the jail, they were lasting like an hour and stuff like that without the wee boys coming in and this call was being recorded. So you're damn tooting that they were listening and hoping to get some juicy bits in the conversations that he was talking to his family and that about, and then he didn't, and then that's when he wasn't getting later on in the phone calls, it was this call is being recorded, jumping in every 5 minutes or so, and then he wasn't getting as long as what he was getting in the beginning because they realised there was no way they were going to get the information that they wanted because it never happened.
Yep.
The overall effect is that a prisoner or defendant, innocent or guilty, can't have a private conversation with his lawyer or his clergy or a drug counselor. Those drug counselors that come to these rooms. And, to add a little bit to this, I got in a pretty good debate again about this last week on Reddit with 2 or 3 individuals. I'm sure yours probably read at least some of it, but this what I'm showing you guys was pointed out, that Conrad Best was made aware, but that doesn't really take away from the fact we don't know when the cameras were installed. We don't know how long. He's been going to these privacy rooms and talking to a lawyer and saying whatever. It doesn't matter, I'm sure if there was anything, well, you have to say if he had said anything incriminating, they can't play it, right? They can't. There's no way they can play it legally and get away with it. They can't do it.
They can't do that. But Jack, the whole idea is that the attorneys can strategize around the type of questions that they're asked during the trial.
Yep.
Because they know that Stephen is not going to take the stand. So therefore they can be very strategic in what type of witnesses they bring to the stand and the type of questions that they put forward to those witnesses. But the other important thing is what is the questions that they don't ask. So therefore, if Stephen is having these private conversations with his attorney and he's saying things like, oh, look at Scott, oh, look at Bobby, oh, look at this, look at that. So they can strategize and say, right, make sure that this is a no-go zone, right? So therefore, it's what the jury doesn't hear that's just as important as what they do hear. So this is an incredible invasion of privacy, and is it a huge leg up to the state? I mean, imagine if Stephen turned around and says, okay, I I want to hear all the recordings of the state when they get together at the end of the day and strategize what they're going to do the next day. It's that ridiculous, right? So how come the state has got the privilege to hear what Stephen says to his attorneys, but it's not a two-way street?
That's right.
Right? And
That's
so
right.
that is serious.
Well, you know, a guy like Kratz, you know, he would say, "Oh, that's work product. You can't have that. Well, you can't have that."
Kratz was clearly building stories because we've seen in the jailhouse cause where Steve's talking to what's her face, Jody, and says, "Oh, I'm so sweaty when we have sex," and then right away Kratz starts using how sweaty Steve is.
Oh,
you know, and we've seen like 3 places where that happened.
Wow.
So it's helping him build a story at any rate.
That's correct. And you see, BB, guys, this is so important, because if Stephen is hearing the very words he says in private, then that, you know, that should send a shiver down the spine of Stephen and also his defense team.
That's a red flag.
Clearly they're getting information, privileged information. But Ken Kratz will turn around and say, well, you know that telephone calls are being recorded, and I'm going to use every piece of information to my advantage. Okay, that's one thing. But lawyer-client privilege in a locked room in jail, that's a no-go zone.
With guards at the door?
Yeah, which goes to show, was Ken Kratz actually in that room casting that shadow in the right-hand corner? Was he actually sitting there? You know, it's ridiculous. He might as well have been sitting there.
It is totally ridiculous.
And obviously all the shades were pulled in that room, so
yes,
Beauty was trying to get as much privacy as possible, because you could see all the shades pulled.
That was pretty normal, apparently, according to Emily Matesic and the other two. I can't. We'll get their names here in a minute, but they indicated that the shades were pulled, you know, when they got in. You know, another thing, and I'm going to bring this up now because I'm not really going to show the jail policy. We'll talk a little bit about it, but jail policy was that anyone that went into a privacy room was searched, subject to search. Let me rephrase that: subject to search. So I can't really say that, you know, they should have, you know, searched Buting before he went in, but because he's a lawyer, you know, I get that. And, you know, it's a little professional courtesy, you know, going in, here it is, and not search him. At the same time, jail policy's changed, and we'll get more into that. I know we've probably talked about it to at least some degree, but there are probably people out there that don't know what I'm talking about now that that actually happened. Remember, this is July of 2013 that he filed this. You know, people are asking, I had some questions. Why did he wait this long? And I can't answer that question. I don't know. I don't know why he waited this long to file this pro se motion about this. But nonetheless, he did. One more thing, and I think this is another head scratcher. We don't really know exactly how Ken Kratz knew to FOIA this footage. Somebody had to have told him that, you know, there's security cameras in there this stuff's being recorded. When did that happen? You know, it just brings up all kinds of questions to me. It's basically the state cheating. I hope everybody can agree with me. They're cheating. So anyway, let's get through this pro se motion. We'll get through this pro se motion, and we'll move a little bit more into some other documentation. But anyway, his argument was Avery was denied his rights under the Article 1 and 7 of the Wisconsin Constitution, the Sixth Amendment to the United States Constitution Council, which basically that's your rights to due process. I'm not going to read all this, but I clipped some of this out so, you know, everybody could kind of see this documentation for anyone that wants to read through it. There's actually several documents, but we'll get a little bit more into where this leads after he filed this motion with the court. But basically, you know, Article 1 and 7, the Sixth Amendment right to counsel protects the integrity of the adversarial system of the criminal justice by ensuring that all persons accused of crimes have access to effective assistance of counsel for the defense. Yeah, and this goes on. Again, I'm not going to read through all this. It's just a lot of, and you got to say, boy, Avery did pretty good for. I'm sure he had help in writing this, and he made some mistakes in it, some spelling errors, but considering his education and his IQ, he actually did pretty well. What's this next one? The right to counsel exists in order to secure the fundamental right to a fair trial, guaranteed by due process clause of the 14th Amendment. Again, that's why I said before, 6th and 14th Amendment, we're guaranteed that. Now, I don't care if you're, a multi-billionaire or if you don't have a pot to piss in. Those rights should be guaranteed. Anyway, he goes into his argument and, basically being monitored through this process. Again, this date here, July 20th, down here at A, July 20th, 2006, that's when Pete Bass wrote that memo. This plays a little bit into part of this section I'm going to show a little bit later with the PDF about this actual motion and what date that was. So remember that date, July 20th. Avery talks about he talks about the note, and he says this act alone had a chilling effect on Avery's Sixth Amendment rights. Avery was unable to offer full and frank information and could not be probed by his investigator for pertinent information that would have or could have aided Avery's investigative efforts. So he's right. The state continually monitored Avery's protected conversations with his defense team. Let's see. And then monitoring of Avery's attorney-client conversations in the jail. And he goes more into that. So, all right, we're at the FOIA request. Before we move into that, any comments or questions before we go any further? No? Okay, so basically, Avery filed this with the court. Let me turn that back on. There we go. He filed this motion with the court, and it went to Judge Angela Suckwitz, that we all have come to know and not love. And she had to react to it. I guess she felt she did. And so she ordered an investigation. I wanted to show this too if we haven't looked at it. I have to back up. Please pardon me. When Buting on this, it says here, March 17th, you were asking me, Doc, when Buting took that camera there and was recording Avery, it says, Attorney Buting was observed by 702, 705, 709, and 714. Why it took 4 officers to observe Buting in this room, and Avery and Buting in there, I don't know. Taking a video camera out of his briefcase to video Stephen Avery. A phone call was made to 801, and I'm pretty sure that's yours. Isn't that Poggle? Isn't 801 Poggle? We lost yours. He stated that we are to advise Buting that he is unable to video Avery per 801.
Yeah, 801 is Poggle, yeah.
Thank you. I thought he was. So when entering the conference room, number one, Buting was advised by 714 he was not allowed to video tape Avery. Buting said, okay. So then, this was March 17. And then later that day, Poggle writes a memo to the jail personnel. In fact, immediately, anytime Mr. Stranger Buting visits with their client Stephen Avery, they are to be checked for any type of recording devices or other contraband not authorized by me. On today's date, Mr. Buting brought a video camera to the visiting room in his briefcase, which was not detected on the security camera and by jail staff, or which was detected by jail staff. The briefcase, their briefcases are to be inspected and searched for any device not authorized. Any detected contraband is to be confiscated. If he should refuse to allow for the inspection of their briefcases, they will not be allowed to bring their briefcases into the jail. If they have a problem with this order, they're asked to take it up with the judge who is aware of the situation, Sheriff Jerry Poggle. So you got to remember the fact, and we'll get into a little bit more later, jail policy was changed because there were 3 reporters that were allowed to go in and video for the news, have a on-camera interview with Avery. FOIA didn't like it. FOIA and Johnson, they were raising hell. This is back in, late 2005. They were raising hell about it. They didn't want him to talk to anybody, and they were trying to get him to stop. And I guess eventually, the lawyers approached Poggle and had them put a stop to it. I don't know exactly how that all worked out, but it did. So any questions before I go? I'm going to pull up the motion hearing.
Jack.
Yes.
Jack, just to answer T1, yes, I was still in bed under my covers. But the serious question here is, why do you think Buting actually videotaped Stephen Avery in the first place? Is it possible that Buting actually had an inkling that he was being recorded and wanted proof by actually recording the session?
It's possible. See what they would, if they would react. It's possible.
Yes.
Isn't it ironic that Pagel can have a recording device in there when he's not supposed to, but God forbid Buting do it?
Exactly. Isn't that the most hypocritical thing you ever heard?
Yeah. Well, isn't it interesting though?
It is.
That when Stephen first got arrested, and the news reporters were asking him where Stephen was, and they said, I don't know. Remember?
Yes.
You just wonder whether they were monitoring him right then and there from day one, as soon as he got arrested.
I think they were. I mean, I can't prove that, but I think they were watching him from, when they arrested him on November 9th. I think he was monitored from the time they put him in CASO until the time he was, sentenced and sent off to whatever prison he went to. I think they monitored everything.
I think he was monitored even before that.
Oh, I definitely think they were definitely watching the salvage yard. There were too many incidences where they were right there.
So my question is, why did Stephen get this special treatment? Or did they record all prisoners, or Stephen in particular? What was so critical about Stephen? And the answer must be, he just happened to have a civil lawsuit against the MTSO, Kaseric, and Vogel. Oh, wow. What a remarkable coincidence.
Isn't it, though? Well, I think...
Well, and we all think this corruption goes way back. So maybe this is just standard operating procedure. Maybe they've had these cameras there for a long time, and they record everybody to try and get the goods on anyone. But definitely get Steve Avery at all costs.
Yeah, I agree. Correct.
So,
Barb says we all were. Yeah, I believe that. I do. I agree with that.
Well, what did she say, Sammy? I'm trying to follow the comments, but I see. I got it now.
Yeah. We all were. Yeah, I believe it.
I mean, I think that they were. We know that they went back at least. I don't know if they were actually monitoring calls before the October 31st timeframe, but we do know that they did get records from everyone that lived on the yard, going back to at least June of 2005. At least that's what Kratz told Mr. Meow Kaczynski when he was assigned Brendan's case. So there were months prior to anything happening that they had went back and subpoenaed. So that's interesting. So anyway, if we'll get there, because I'm going to move forward with this motion, and as everybody can see that date there, this is the day before Conrad Betts wrote his memo. This is one day prior. Okay. And this motion, it covered several things, but ultimately what this motion is about is Buting and Strang were trying to question jail policy, how the three reporters that got in there to record Avery was treated, and how they had John Burns on the stand to help for him to explain the differences in the types of visits and jail policy and that kind of thing. So that's what really this, and it gets a little convoluted. We're not going to read all of it, but there are several pages. If I don't include it, it's less effective. So here we are, July 19th, the day before Pete, I guess, went to talk to Avery about whatever. And I believe this starts on page 96. Let me get that forward here. Let me try that again. Okay. We can see it's going to come up there in a minute. Lieutenant John Barnes gets called. Now, remember, he's been at the jail for about 4 years. So I'm going to read through some of this. And if there's questions, please stop me, because I don't want to just bore people with just reading a document. We've read this in the pretrial. This caught my attention a long time ago. I think people are aware of it. It rubs me so backwards. It just bothers me that someone would be treated like this. And then, somebody of this person's has been there for forever, a veteran cop, that would say what he says, and we know that it wasn't true. So anyway, Mr. Burns, tell us a little bit about how you are presently employed. Answer: I'm jail administrator for the Calumet County Jail. That's my present position. Question: all right, jail administrator, meaning you have general responsibility for all facets of the operation of the Calumet County Jail. Answer: that's correct. You report directly to Sheriff Poggle. Answer: yes. Question: but anyone who actually works in the jail reports to you. Answer: correct. Question: in addition to being a jail administrator, you remain a sworn officer of the Calumet County Sheriff's Department. Answer: yes. In that department, you presently hold the rank of lieutenant. Answer: correct, yes. Question: how long have you been in the position of the jail administrator at Calumet County? Answer: it's been 4 years. Question: continuously? Answer: yes. Question: so for the period of time, let's say November 9, 2005, through the end of December 2005, you're the jail administrator. Answer: correct. Question: did you bring with you today any documents? Answer: yes. From reading the subpoena, I brought a copy of the visitation policy that's used by the jail. Question: thank you. May I have that? Answer: sure. Question: thank you very much. I've got several questions about this. You have given me 3 pieces of paper, pages stapled together, but the first 2 are 2 sides. That is, there's typing on both sides. Answer: yes. Question: all right, this is an excerpt of a larger book of jail rules and regulations. Answer: yes. Question: these rules were in effect in this form during the period between November and December of 2005. Answer: yes. Question: for ease of reference, that's the time frame I'm going to use here, that 61 days here, unless I tell you otherwise. All right. So again, and I didn't point them out. I've actually got them highlighted in this document here, but he's really talking about this time frame I mentioned earlier about the reporters that came in and had an on-camera interview with Avery. So he's trying to drive this point. Exhibit 7, I think this is the book or the papers that Burns brought with him, marked for identification. Question: I want to be careful about this, Mr. Burns, because although I accept what you said, that these rules are unchanged and they were in effect as you have been given them to me in Exhibit 7 in November and December of 2005. The last page looks like it says they were approved on March 24, 2006. Answer: that's correct. Many of the policies that I personally work on, I set them for an annual review, and I look at the policy and determine if there needs to be any changes. When I checked my history documents, the previous change to the visitation policy was made in 2003. So this policy, although it was examined and reviewed within the past year, it was unchanged. Great, thank you. So basically, he's saying he reviewed it, didn't make any changes. He just acknowledging that he reviewed it at that date. Okay, let's move on here. They just talk about all kinds of things with the various employees, and I'm not going to get into all that because we don't need to. Let's see here. Okay, we're going to get into a section here where we're really driving to the public coming to visit versus a lawyer or clergy or whatever that we talked about previously. Question is, almost self-obviously, members of the public do not have access to the inmates other than on terms under the control of yourself and the people working for you in the jail. Answer, correct. When I say members of the public, that would include lawyers for inmates? Answer, yes. Question, religious advisors or chaplains, that type of thing, who may wish to see the inmates? Answer, yes. Question, Alcohol Anonymous counselors, those kinds of people? Answer, yes. Question, family members? Answer, yes. Question, friends of the inmate? Answer, yes. Question, and even law enforcement officers? Answer, yes. Question, would they would gain access to an inmate in the jail, that is, law enforcement officers would through you or your corrections staff? Answer, correct. Question, that said, there are different rules that apply to some of these different groups I have described, correct? Answer, yes. Question, let's start with the lawyers and the clergy members. And I think we can group in probation and parole agents there as well, correct? Answer, yes. Question, there's a specific rule that applies to the three groups that I have just described. Answer, yes. Question, their access will be permitted to the inmates for lawyers, clergy members, probation, and parole agents during reasonable hours. Answer, yes. You ultimately decide what those reasonable hours are. Answer, yes. Question, reasonable hours would not include during shift changes. Answer, correct. It would not include when you are trying to serve meals. Answer, correct. Question, that is, you as a jail administrator are responsible for the care, feeding, and safekeeping of inmates in your custody. Answer, yes. Moving visitors or dealing with visitors distracts from or requires manpower. I guess I would put it that way, right? Answer, yes. Question, so at critical times like shift change, when one would be leaving, another would be coming, it's not reasonable to expect changing shifts also to juggle professional visitors. Answer, generally not. If a visit was started prior to the shift change, they may allow it to continue. Question, but probably not to terminate, requiring movement of the visitor out and the inmate back to the cell during the shift change. Answer, correct. So that means they're just going to let the interview continue. Guards will change places and whatever. Question, same with mealtime? Answer, yes. Question, might allow the inmate to continue visits through the meal and maybe you would all hold a meal for him, correct? Answer, yes. But you aren't going to do, you're not going to be doing inmate movement or visitor movement during the actual process of feeding. Answer, generally not. Again, it's not important to move the inmate. They will hold a meal. It really depends on the situation. And the guide is reasonableness, as I understand the rules. And that's an important word that apparently plays a big part in their John Burns policy for the jail. Answer, yes. Let's move on along here. I'm not going to, I told you this is a lot of, he was really trying to drive down the point of segregating these differences in how people are treated that come to visit versus, being able to get to a contact room versus being forced to talk on a phone. And again, the phones are marked. You're being recorded. And this is my whole point in talking about this. So it's clear. Question, lawyers, probation agents, and clergy members are allowed what's called contact visit. Answer, in most cases, yes. Question, and Exhibit 7 refers to a little bit obliquely in a paragraph. What is it? I'm looking at, and he names it off there as in, I don't think that's right, as in golf. Oh, okay, G is in golf, right. Answer, yes. Identifying the two visiting rooms that may be used by clergy, lawyers, and probation agents, yes. Question, those are what's called contact visit rooms. Answer, correct. Question, by contact visit, there is no barrier separating the inmate from the visitor. Answer correct. Question, no need to use a telephone to speak through the barrier. Answer correct. Question, law enforcement officers are also permitted contact visits. Answer, yes. Question, law enforcement officers also can visit at any reasonable hour. Answer, yes. Question, their visits can last for a reasonable duration. Answer, yes. Question, so in many ways, they are treated much like lawyers, the clergy member, or probation agent. Answer, yes. Then he's talking about the length of visits here I mentioned earlier. Question, rules limiting the length of visit. Answer, yes. In the case, your jail, to 20 minutes. Answer, yes. And that's through the contact barrier when they have to talk on the phone. They don't allow them to visit very long at all. Question, there's no limit on the time length of a lawyer's visit or clergy member's visit other than reasonableness. Again, answer correct. Question, so you've got this visitation schedule for friends and family members set up Thursday and Sunday evenings? Yes. Question, females from a certain time, males a certain time? Yes. Question, these are not contact visits. Answer, no. Question, at least ordinarily? Answer, yes, ordinarily it's a non-contact visit through the phone. Question, and answer, glass barrier. Question, reinforced glass barrier? Answer, yes. Question, okay, these visits are routinely tape recorded by the jail? Answer, yes. Question, contact visits are not tape recorded by the jail? Answer, not. Question, just not at all? Answer, no, there is no recording device I'm aware of in there. Question, okay, and you would know? Answer, I would hope so, or I would hope to. That's the end of my long spiel. You guys talk about it.
I'm still remembering July 20th.
I knew one of them somewhere had said that they knew for certain that there was no cameras in that room. Well, that video proves I'm fucking right.
Well,
that's what I said.
I think that you got two scenarios in my opinion, and I'll shut up and let you guys talk about what I'm going to say. Number one scenario, John Byrne did not know. This was done surreptitiously behind his back. He was not informed. And life goes on. So he didn't get up there and lie. Number two scenario, he did know. He was afraid to admit it in open court in this scenario. And he lied and perjured himself to protect.
Okay, I'll take the latter one. I'll take the latter one.
Well,
I mean, let's just face it. They're going it all. They just make the rules when they want to here, and maybe they didn't. Maybe he didn't know about it. But
I found that hard to believe, Linda. I really
so do I. So do I. I mean, I really do.
I mean,
I really do.
When we did,
they have to go in and retrieve it somehow, don't they? Or it has to be a computer or something. It's going.
See that's the thing. That line has to be going somewhere for a monitor and recording recorders, right?
Exactly.
And I wanted that information as to when it was installed.
Right.
So,
and it does say, there's not supposed to be no devices there. So somebody's lying somewhere. Okay. We know that for a fact. And it's definitely not giving Stephen his rights. I mean, where does he get his rights? I mean, they just took everything and stomped on him from the beginning all the way through and everything they could do on him. This is not fair.
And Jax, I don't think there is going to be any documentation about any camera being fitted in that room, because there wasn't a camera fitted in that room. As I says, that's one of these snake cameras, and they've just pierced a wee hole in the wall, or as Doc says, it's in the fire alarm.
Yeah.
And you can easily get them in the wee cameras and put it in the fire alarm. So maybe you're right. Maybe that other guy, the one that's just said there that there wasn't. Maybe he didn't know, and he he was done to it, and it was what Kratz and that done behind their back. But somebody knew that it was there.
Well, I think several knew. I think it was a kind of a probably, well, it had to be kind of a running secret because they didn't have any signage. Pete Bass said that in his memo. He looked around. He didn't see him after he was told, and he didn't see jack shit in there. So, this he wrote that a day after this hearing. God, it's so bad. It's so bad to me. I just cringe, and when I think about it, and I think about, I've had friends that have been locked up. I've had family that's been locked up. And you think about those moments, and you think, man. And you go into to talk to him, or his lawyer goes in to talk to him, and they may be being recorded secretly. And that's not the way the system is supposed to work.
Yeah, where's your rights? To private counsel, to be able to, you might as well just have one lawyer that works for both sides. There you go.
Here's another. Go ahead, Doc.
I was gonna say Jack 61, but isn't this a classic case of plausible deniability? So essentially, you only have a small group of individuals who know that there is a recording device in that room, and all they have to do is swap it in and out, right? So sure. if it's within a smoke detector, they can just simply change it, take a ladder and swap it out for a real smoke detector, because it's got a plug. Right, so it's very easy to do.
That's right.
So if you have plausible deniability, you can go in court and say, hey, I knew nothing about recording devices, and the guy's actually telling the truth. Yet clearly there was a recording device in there, because Ken Kratz let the cat out of the bag, so to speak. So we know that he was recorded. If that's the case, was Brendan Dassey also recorded as well?
Exactly.
Probably.
Well, and that opens up the other end of that, Doc. How many other inmates were recorded? Was this a targeted kind of thing to, just say Avery and Dassey, or was it a broader kind of thing? Because then we don't know. We simply don't know. It's a vacuum of information that it's a rabbit hole, but we can't really dive down into it because, I didn't talk about it too much in this, but we'll get more into a little bit here about where this led to. But is there any questions that anybody? I really have been following the chat and see if there's any questions that have come up. I'm kind of looking here, but
not really.
I mean, it's just damning to me, and I know I'm repeating information that we've gotten out there before, but it bears repeating because it came up, and I saw every excuse under the sun. One person I was debating with, they called it security, and another person called it this. They were just monitoring the situation. Do you know
Paul Ward did say if KK had this recording from the room, what else does he have?
Exactly.
That's right. That's exactly right. It begs the question of what else do they have that we don't know? We obviously, I mentioned it yesterday during Uncle Ken's Doc's reading of Uncle Ken's book, this 8mm tape that was undisclosed. It's pissing Fallon off, We didn't know anything about that till a month ago. How many more pieces are there? And it doesn't matter if they're if there's nothing on it or not. We don't know that until we see it, or the lawyers don't know that until we see it. So,
can I say something, Jax?
Please.
Because I was talking about this with Kaboom Blazoom, whatever his name is.
Oh yeah, Boom.
Well, yeah, Boom. Yeah, there's some similar level of corruption going in other cases, and you really want to look at other cases in the surrounding area, because I was wondering if there's some kind of they take the same level of sloppy operation to this. You know what I mean?
Well, it's like that. I get what you're saying. It's like that they're just doing what they want.
Exactly. Yeah, they do whatever they want to do. So it's ridiculous.
Think about this for a second. I mean, you have to wonder: does the DCI know what's going on there?
Yeah, they're in on it. As far as I'm concerned, yeah.
Well, I mean, if they if they knew and didn't do anything, that's another big problem because they're the state police, they're the state agents. They're reporting directly to the AG. That's another huge problem if they knew. I don't know how they didn't know.
No, exactly. The whole operation is so how do you say this?
Ridiculous.
Yeah, well,
you have your rights taken from you, and then you get your freedoms taken from you because of it. What the heck? That isn't fair.
I was more thinking like, these rural counties, they have like a very bad operation going on. You know what I mean? So compare this to some other level, like, the same operation going on in New York, that would change they would get some different results, right?
Absolutely.
You get some, there's some bias going on in these rural counties.
Can I also make the...
Yeah, go ahead, Doc.
Sorry, Jack 61. I was going to say the other possibility now, this is terrible if this is true. Imagine if they had a hidden microphone in the jury room as they were deliberating. And so essentially they can get the heartbeat of what was happening in that court, in that room. So hence, you remember how people just suddenly went in there with pizzas and I think Remica was actually told off as well. So one wonders whether they were actually listening in to what the jury were actually deliberating and probably panicked when the first count was like 7 not guilty, right? So one wonders whether they were listening in and tried to use strategies in order to essentially change the conviction from not guilty to guilty. Just a thought. If they were that low to record Stephen in a private conversation with his attorney, I'm absolutely convinced they probably had a listening device in the courtroom. Where the jury was.
You couldn't say, you'd have to think that, because I mean, you're thinking of it right now. How many other, you know what I mean? It's, if you can think it, it's a possibility, and I do believe you're correct.
Yeah, you have to go back to the examination of the whole crime scene, and they trashed the burn pit, they trashed this whole fucking house. I mean, they're willing to go over and beyond. So why wouldn't they go in this way? Same thing.
Extraordinary links in my opinion.
Yeah.
Correct. And don't forget the massive response from law enforcement on November the 5th, the Saturday, when one considers it was a missing persons case. They didn't find a body. They found no evidence that a murder took place. They found a vehicle, right? And they never entered the vehicle to determine the degree or severity of a crime having taken place. They never went in there according to the official records. So, to me,
and
that
they quit
suggests, that to me suggests that these guys were pre-armed, pre-warned. They had a plan in place.
Yep.
All Pam and God had to do was blow the whistle, get on the phone and say, guys, I found the car, come in. And that's exactly what they did. That's exactly what they did.
Cadaver dogs an hour later.
How can you trust one thing? If they planted a key, they planted other things. If they had listening devices and cameras, they had them in other places too. They listened to all of his phone calls. They did use them against him. The possibilities of this strictly on him breaking all these rights and violations is very strong. That the whole thing from beginning to end is corrupt.
Well, I mean, if we take everything as a whole, and we think about exactly what you just named off there, and you guys have been talking about, the key, and Kratz, you were talking about yesterday, Doc. Well, even if the key was planted, what? How can you know? How the fuck can you normalize that kind of thing?
Yes, correct. But you see, the other thing is, if Ken Kratz made that statement, which he did, that sends a shiver down the spine of any potential person involved in planting.
Sure it does.
Right? So basically what it says, Ken Kratz is going, the key may have been planted, wink, wink, as in, I'm on to you. Because if you look at Ken Kratz's book, how many golden nuggets has he written in his chapters that we've read so far?
Oh my God.
He's done so many embedded confessions. It's actually not, in other words, he's actually outlined the plot of what the planters actually did without actually saying it.
You got it.
It's ridiculous.
It really is.
Yeah.
Well, I look at all these things that we've already talked about. We actually talk about quite a bit. We haven't talked as much about this aspect of it because we didn't really see. If you watch The Making a Murderer, the video of that Avery or that Buting took of Avery is in there, but you don't see the room, that the video that we saw. So you take all these things to account all the way through, and the steps that were taken. Them bugging the jury deliberation room would not surprise me in the least. It just wouldn't. So anyway, okay, if there's no more questions about that, what I'm going to do is we talked about earlier what Avery filed his pro se motion. It went to Judge Angie, and let me open this up here. I think this is it. Yeah, here we go. What you're going to see here coming up is this. She assigned some investigators to this case to look into to see if there's any truth to what he's saying. Avery's accusing being spied on by the county. Let's just assign someone to look into it. Now, I don't think I have everything. I just pulled up about 3 of these from this guy named Thomas Aquino. He did do some investigation, and as you can see, this is dated almost 2 years after Avery filed. This is January 22nd, 2015. And he's writing to Judge Angie, and just a status update. I actually think there might be another one prior to this. I can't remember, and I didn't really dig that hard. But I'll read some of this. Again, if anybody wants this information, they want to go through it, just let me know. I didn't provide a link to Kat to link everyone because it's not my information, and I would have to get permission. I don't think it would be an issue to getting permission from seeking to share the information, because that's why it's being shared. But I would definitely want to ask her first. So just let me know if anybody wants it. Anyway, I want to provide an update on the status of this matter. The Calumet County Sheriff's Department responded to my public records request by providing me with the names of jail officials present when they observed a defense counsel removing a video camera from his briefcase while conferring with Mr. Avery. However, the county refused to provide any contact information, citing safety concerns. The county likewise refused to provide any information about the department's ability to monitor or record the conference room, other than to say the county did not have a written policy covering the matter. Now, isn't that really interesting? In any event, I need additional time to locate and contact officials disclosed by the county. In addition, Brendan Dassey's counsel has not been responsive to my request for any policy police reports or search warrants, returns, and affidavits related to the seizure of the family computer, which is interesting. As noted in my letter dated December 8th, 2014, defense counsel has informed me that the police officers seized the computer shortly after they discussed the possibility of searching the computer for evidence that may implicate another suspect. I need additional time to locate any such records or determine that they do not exist. For these reasons, I request an additional 45 days, Monday, March 9, 2015, to either supplement Mr. Avery's Wisconsin his filing or otherwise update the court. He probably copied, he copied everyone under the sun, Fallon, and these other people. So here we are. He's in the midst of this 2 years later, trying to get information. It's interesting that the Dassey computer, I really had missed that before, Linda. I don't know why I did, but I don't remember reading that about this computer. That's interesting. It is interesting, right? So anyway, the next...
Yeah.
Any comments before I move forward about this?
I think I'm madder now, Jax, about this than I was before.
Well, hell, fuck yeah, I'm bad as hell. Every time I think about this,
like, I cannot believe it.
I know.
mean, it's just it infuriates me even more now than it did when we first discussed this last year. It's just really got me piffed off, man. I'm telling you,
it blows me away.
Well, I think what it emphasizes is what you guys have actually said, to get Avery at all costs, because when one considers this case as a circumstantial case, it was not a very easy case to win, because, if you look at Brendan's so-called coerced interviews that he did, it's all rubbish. It's all garbage. Nothing can actually be backed up. So the state pulled out all stops, fair or unfair, in order to get Stephen convicted. Why? Because that lawsuit was going to sting, not for money, but I think if a corruption probe was done into the MTSO, it would have dragged everybody in, including, now wait for it, the crime lab.
That's
the crime lab was going to be under incredible scrutiny, right? And if Stephen got off, every prisoner who had anything done to them by the Wisconsin State Crime Lab would have put their hand up and said, I want a new trial. I want new forensic evidence done. It would have been a complete shambles.
And especially anything Sherry Culhane worked on.
Anything that Sherry Culhane did, especially...
Looked at, breathed on, sneezed at.
especially historical cases that involved hair analysis.
Right. I mean, she's never did a deviation ever since then, has she? Never once did she ever break protocol. But hey, sometimes you just got to do that to make it fit, right?
Common sense gone.
Common sense. Correct.
That guy kills me.
Yeah, so, the stakes for the state were not just $36 million, but what it would have opened up a can of worms. I look at this case very much like what happened with those two lab techs that were working on the narcotics.
Yeah.
Right.
Oh my God.
Now remember, the Attorney General said, "Oh, don't worry, it's only 2 cases that were affected." Well, guess what? 10,000 cases got overturned. 10,000.
It was a disaster.
Correct. And
these guys ain't even willing to admit anything wrong. And it would take down the whole town, a lot of people's jobs, a lot of their homes, everything would have been lost. There's so much could have been lost from this for those.
Would have been everybody in the pool. Everybody in the pool, right? It would have been.
Yeah.
Correct.
So, yeah. Well, I mean, moving forward here a little bit more, this is the next update. I think that's actually available, and it's obviously beyond the March whatever date that he said. This is July 20th. Dear Judge Suckwitz, this letter is to confirm that during the conference call between the parties and the court on July 17, 2015, it was agreed that by August 17, 2015, I will file either an amended post-conviction motion or letter notifying the court that I have determined that there is no merit to the eavesdropping post-conviction issue Mr. Avery has raised in this pro se motion. So this is July 20th. So he's continuing to not really get any information. And again, remember, he's approached CASO. They've not given him any video. There's apparently no written policy that he's being made aware of or given, which I really doubt that. There had to be something. And then this, I think this is the very last one, actually, I'm sure it is. And it's going to come up here. It's September 2nd, 2015. Again, to Judge Angie. Dear Judge Angie, please find the enclosed petition order for payment, court-appointed counsel fees, and supporting documents. The petition is completed from a form petition found on the Manitowoc County website. This is him going and begging for money, and I want you to pay attention because Linda will remember this that I raised. I never really went anywhere with it. Maybe I should write that one down because I actually completely forgot about it.
Write her down.
This petition includes a request for a reimbursement of $315 in expenses for investigative services. The investigator's invoices are included in the enclosures. The court approved up to $500 in such expenses at the June 12, 2015 status conference. The total amount of fees is requested as $3,206 based on 45.8 hours at the first court appoint rate of $70 an hour. The number of hours expended is reasonable in light of vast scope of the underlying proceedings and the nature of the issue considered on the appeal. The investigation generated approximately 1,500 police reports. From where? CASO's 1,117 pages. So anyway, that really raised my eyebrow because where else is he getting his, where did the rest of this paperwork originate? And there are 24 days of trial. I was appointed in response to the state's concession that Mr. Avery's claim that investigators had eavesdropped or otherwise monitored his attorney-client communications would require additional factual development before the court rule. May 13th, 2013, final letter, page 3. And there is that letter is included in this stuff. I didn't include it here because it doesn't, it may apply, but I'm not going to include it here because I'm after the other end of it. Page 3, I reviewed the investigatory reports and transcripts and spoke extensively with trial counsel to assess whether we could show that there was investigatory leads that could have only come through improper eavesdropping, and if so, whether it prejudiced Mr. Avery's trial. For these reasons, I respectfully request that the court approve petition. If no objection is, and we don't have that page. That's the end of it.
Yeah.
Yeah.
I slightly think that his rights are taken.
Well, I mean, it says there's 6 pages or 8 pages here, and clearly you can see down here at the bottom. Well, you can't see it. There's 2 pages, so we don't have the rest of it. So,
and
anyway,
why is that? I wonder.
Well, Yoris can chime in here if he wishes. A lot of the DCI reports that we got, there are missing pages, even beyond maybe a header, maybe even beyond a header page getting cut off. I've seen several, and I've not looked at every one of the DCI reports that he and Rookie got. So,
well, it just goes back to show you that if it was all clear and good and it was so strong, they'd be transparent about it. They'd go on with this, but there's so much dirt in this case. There's so much getting overturned on, coming out, and there's so much violation here. This is just going to be, this is going to blow some people away. I wish there was no immunity.
Well, yeah, there was, I don't remember what state it was in. You guys can maybe be able to remember better than I can, but that I posted the other day that this this total immunity is they're going to end it, and there's going to be real punishment for prosecutors that cross the line.
Oh, that'd be great. That'd be fantastic.
They would have to get the Supreme Court to overturn it, and when I was researching, I only found that there's only 2 ways to overturn a Supreme Court ruling. I hope there becomes a movement behind it after everything that goes on in the court, and the way prosecutors and judges can just get away with this type of stuff with no repercussions. I hope there becomes a movement on overturning that ruling for sure.
Yeah, that's the only thing that got to happen. Overturn immunity.
Yeah, I completely agree. This total immunity that prosecutors have, and we can name off. I can rattle off probably 10, well, at least 6 or 7 right now that really broke the barrier of things that they did to win a case, not to get the truth.
I just happened to make a list the other day in reference to Timothy Henderson resigning in Oklahoma.
Oh my! That's a disaster.
One of their attorneys got on the news and made a statement that this isn't something that happens every day, nor is this something that happens every decade. And within 5 minutes of me doing research, within the last year, I pulled up 14 judges and prosecutors that had either resigned or looking at charges because of sexual misconduct. And out of those 13 or 14, one was a woman.
Wow.
So it is very, very, very common in the court for misconduct. Very common.
Well, I think we go ahead, yours.
How does this, get put all under the rug? How does that happen? I mean, if that happens in here, it's like all political and all, people resigning and all that stuff. Why is there no repercussions?
I wish I knew that answer. I think that's the golden answer.
I wonder that too, because we literally just sat and watched the corruption on our TVs along with however many millions of other people, and we watched them get away with it while watching it on our TV screen. So I definitely have that question too.
Well, you think about the fact that these judges are connected to other powerful people in authority, and they have secrets, and then those people are connected to other people that have. And I think about the Epstein effect. Pardon my how freaking gross that is, but it's true. That guy had dirt on everyone. So, this effect of these more powerful people being protected, and I get the fact that you don't want prosecutors being faced with frivolous lawsuits because they're going to come, and that's there's nothing wrong with a prosecutor being zealous in his going after the truth in a case, not a prosecution or a conviction in a case, and there's a total difference in it. And and that goes back to our system being, it being turned towards conviction instead of towards truth. And our little band of people that are placed all over the world, and the people in their own countries, they're facing a lot of the same crap.
Yeah, but if prosecutors are not immune to prosecution being wrong, that's a whole difference there.
It is, because they would be far more careful about, March 2nd, 2006 press conference where he completely, went after. That was another thing, the press conference that Kratz did, they said it was in retaliation because Avery had been talking about being, framed by the cops and the state and all that. According to what I read, this was in because he's allowed to do it because Avery had been speaking out. But the truth is, who just got arrested and what was the press conference about? It was about Brendan, and Brendan had never said a word about being framed. Oh, not a word. Yeah. So they used this as a segue, and he was allowed to get away with it.
Well, and the press conference is just the tip of the iceberg. Remember Neverly and Sammy when we did that powder puff on that expert that Zellner had that wrote that scathing report about every single thing Ken Kratz did from beginning to end, all the way down to him emailing him in jail after all this was said and done, is all wrong. Everything he did is wrong.
I remember that clearly.
Yeah, I can't remember the dude's name.
Me neither.
But he wrote a scathing report. And every single step Kratz made is wrong, bad, illegal, wrong, bad, illegal.
Appalling and illegal,
Yeah, he wrote a scathing report. It's one
Yeah,
of
and
some of
there's-
those experts.
Yeah,
I believe
and
it was
if
a law professor.
Yes,
Yes.
out of New
That's right.
York or something. Yeah.
That's right.
and his
Yep.
CV was like 15 pages, so obviously he was fully qualified and plenty competent. So it's not like a shady dude coming and spewing venom. So that's what he does. Yes. And imagine what accountability would prosecutors and cops would have and to kind of keep themselves in check, because they know if they do something shady that people are going to go after them. Yeah, that would put us up to a lot of shenanigans. And Avery and Dassey are not the first case of wrongful imprisonment. We know that. So, where is the internal affairs that could look into all of this?
They're out of, there's not one like right there in Manitowoc or Calumet County, but they would be out of Madison or Milwaukee.
Well,
but I've asked that question too. I've always wondered why wasn't internal affairs ever involved? But then normally the response is just that DCI? Is that what they're called? Or,
yes.
Yep, the DCI.
Yeah, those guys and the feds were brought in, but it's like that's still not the same thing as internal affairs.
I don't think it's the same thing.
It's not, but like they don't specifically have. I'm in a small town, so if someone were to turn a cop into internal affairs, it's going to go to like the big county.
Right. Wouldn't they have to be in a complaint against it for them to have to do an investigation?
Oh, yeah.
I mean, they're not just going to come out and investigate the police department when they're doing their job if they think they're doing it right. So somebody from somewhere would have had to make a legal complaint against it, and they would have to feel it was strong enough to do something. And of course, nobody said anything, and of course, it didn't get looked into.
Exactly.
Yeah, I wonder why wouldn't they do like every so many years, like I'm in healthcare, right? And every so many years, Medicare comes in, which is the government, body, and they come in and they check our books, they check our practices, they check our, complaints and whatnot and grievances to see if we're doing a good job. And
I think every murder should be looked into, Neverly.
Yes.
Every single murder should be looked into.
Like an auditing, right?
Randomly, yes, like an audit. Exactly.
They audit the hell out of you guys, don't they, Neverly?
Yes, they do, and it's a gruesome
We should do that to every investigation.
But you know what?
We
behave. Because we know they could come at any time, and we better know what we're doing and the rationale behind it.
And if you don't follow policy and procedure, people die.
Yes, and they're all about patience, exactly. And you know what? At the end of the day, although I'm the infection control nurse, it's not just me. It's every employee, every doctor. Everybody's getting looked at. They're looking their credentials. They're looking grievances. How many people have complained about a certain doctor? If so, you know what I mean? Luckily, we're doing really well. But yes, a government
that makes you do a better job,
unannounced.
Right?
Yeah. But then that comes down to, although that it's other prosecutors and other DAs that see this shenanigans and that happening with other prosecutors, it needs to take them to grow a set of balls to come forward and say, look, that's not right what you're doing and stuff like that. I mean, surely Neverly, have you seen any misconduct for somebody at your work or anything like that, you would go up to them and you would say to them, or you would report them.
Yeah.
Yes.
You fucking tosser. What are you doing?
I think they should just automatically do if there's a murder or somebody lost their life, and they should investigate the police department, making sure they're doing the right steps. They just should.
Exactly.
It would help us a lot.
Because to me, that's like a no-brainer, Linda. I agree. Yeah.
Stop a lot of this bias and this tunnel vision and things that are just not really not evidence.
Well,
and people are going in with stupid evidence.
Political. A lot of it's
sure
always
it
going to be political.
Sure
there's a big conflict of interest whenever you've got practicing lawyers in a district that can, vote vote
Right.
their judges in, and it's primarily either a Democratic or a Republican county, well, you're never really going to have a fair shot. You know what I mean? As long as these attorneys keep voting in these judges. And so I don't think that should be allowed. Like, I don't think lawyers should be allowed to vote for judges that they have to go in front of. That's just not fair.
You know, and these integrity units that, you know, I think we all want, they need to be an independent body away from both sides. It has to be an unbiased, independent cross-section of people that understand the gravity of what they're doing and not connected like a crime lab is always connected to the police department. To me, it's just terrible. It's like like you guys were talking about, though, you know, cops investigating their own department. To me, that's just what are they going to say if they hadn't already said before?
Yeah. So, but it's like what we're wanting for Luke is an independent review of his whole trial, and that is nobody in nobody for the Crown Office. It's like I'm not 100% sure exactly how they work, but it's like maybe an ex-judge, but he was the highest judge in the land before he retired, or you know, it's official people like that, but they're independent. They're not going to be just for the poll list, and there could be maybe about 6 or 8 of them, and they look at the case from beginning to end, and they judge everything. So they'll judge if the 999 calls go answered and were treated satisfied by both sides, and how the police were at the scene of the crime, and did this get investigated properly? Did they do that properly? And it'll be the police, the forensics. You know, they'll check everything, and then the inquiry could take a year. It could take 2 years. It could take 4 years. But they'll do it as long as they need to do it to get to the source. And if they find that, say, the police were to blame, then they will say the police was to blame. They done this wrong. They done that wrong. If they find out that it was the police, the Crown, and the prosecution, then they would say that them all, and this one needs to be looked at, and it would seriously, hopefully, get looked at. You know. And that's the kind of thing I think you need over there.
You know, one of the things that really sticks out at me, and maybe to other people here, Doc, you know, maybe he has an opinion too, but one of the things that really surprised me about Luke and Joni's case is that having in Scotland, and then I think about, when I think of that, I think of Scotland Yard and how respected they are in the world, and how these investigators, how that it was such a terrible investigation from the beginning. Would you agree with that, Doc? What's happened? What was the?
Yeah. Well, at the moment, I'm reading Sandra's book, and like I said previously, the problem I have is that I can't get access to the original documents. But from reading Sandra's book so far, the investigation was a disaster from day one. So, you know, we're talking about contamination of the crime scene. That poor girl was left out in the rain and in the elements overnight, right? Instead of protecting the body, protecting the crime scene, they basically left poor Jodie.
Moved the body and poured bleach on the ground?
Yeah, well,
they then bleached after they bleached it, correct.
Yeah, when they first got there, they crumpled up her clothes into one pile, not piece by piece into separate bags like it should have been done.
Right.
It was all crumpled up, and like you were just like scooping up the dirty laundry to take it into the washing machine, you know, just scooped it up like that. They rolled her body from where it was onto a plastic sheet. They cut away bushes and trees and the shrub round about, so that the police photographer could get in to get the photographs and the video. And this was all before the forensics got there. So right away, there's a contaminated scene.
So basically, I mean, right here from the get-go, we can see numerous things that I mean, to me, and when I think about Scotland Yard. I mean, I don't live there, but I've seen many, videos and documentaries, and they're involved. And from everything that I've seen, these people know their shit, and they do everything right. They do everything right. So how does that? To me, the mindset of how well they function as a unit overall, down to this local. I mean, I don't know. I don't remember the name of the town, but whatever. I know they came from, because that was a small village where it happened. I realized, and they had to travel to there.
It's called Lothian Borders Police. That's who it was that started the investigation, was Lothian and Borders Police.
I just think there's a really big problem when it requires more hours to become a cosmetologist than it does to become a police officer.
Isn't that crazy?
That's why we have
right on, Nosy, right on. 1,500 hours.
For me to even just be able to step into a salon and do someone's hair, which I wouldn't do that anymore these days, but I had to go to school for 10 months. And as a police officer, all I got to do is go to training for 6 weeks. Yeah, I'm going to be a rookie and have a partner for a year, but 6 weeks, that's it.
And you got a gun and a badge.
Yeah, and it's just mind-blowing, because not only that, but after 6 weeks, you don't have forensics training, you don't have mental health training, you don't have
any ongoing training.
All you have is you learn how to work the car, learn how to patrol, learn how to do paperwork, learn how to check in. I mean, I know their self-defense is like ongoing and like continuous training or whatever, but 6 weeks is nothing for someone to be able to be in that type of position of power. And that's why we end up with these kind of cases where people just roll evidence up in a bag, throw it in there, and don't wear gloves or stick their hand in the evidence bag.
Yeah. Well,
or make up evidence.
Moving on from, not moving on completely yet, to wrap up the pro se motion. Obviously, there was no video produced. They didn't, they admitted they didn't have any kind of written procedure, which I call bollocks on, as Alice would say. And they were basically uncooperative overall. So, this Thomas Aquino, like him or hate him, he's reporting back these facts to the judge. She has nothing to go on, and she denies it. So, he didn't have the video then at the time. And then, of course, 4 years later or whatever, I can't tell you the exact time, but it was roughly from 2015 when she made her decision denying it to October of 2019 when Kratz released it. We're in the dark, and now all of a sudden, what the? So I don't know, where this could lead us. I don't know where it would lead Zellner, in some other quest or some type of motion, because again, I'm no lawyer. I proudly take my knowledge that I've gathered over the last 5+ years from a lot of people that have helped me. This group included people like, our lawyer friends out there in the land that have come and visited and helped us to understand the process. But I've yet to talk to one of any legal capacity that says this is okay. Not one. So if there's no more questions, I know we're pushing close to 2 hours. I'd like to spend about 15, 20 minutes or so on how to know a FOIA request and get into that. Is there any more conversation we want to have before we move forward? Any questions that are pending out there? I can't really look at the screen right now.
The only comment I want to make.
Yep, go ahead.
The only comment I want to make, Jack, is how deep is the level of surveillance on that entire family prior, during, and after.
Thank you.
Right? Because the cat's out of the bag now. So that, to quote Ken Kratz, if the key's planted, then that brings into question all the evidence, right? So if you've got a surveillance tape, one wonders the depth and degree. And don't forget, there were confidential informants
Yes,
at
that's
the
right.
Avery salvage yard.
That's right.
So you wonder how much information was being directly fed to the MTSO.
I completely agree. It just blows me away that people look at this, and I don't care if you're a guilter or a truther, and you look at this and you say that this is okay. How can you excuse it in any capacity at all? And then you combine it with everything else that we know of all the other things that have come out since we've really been digging in and getting these this documentation, the videos, and the big wonder to me is, how long did Krauss know about the video apparatus set up in the privacy rooms? And my answer is, of course, it's speculation. He's known about it from the beginning. He was the prosecutor there for 25 years.
Not only that, Jack. Remember, Brendan's defense attorneys actually working for the state.
That's right.
That's how deep this actually got. So we can talk about the surveillance, but when you've got feet on the ground, when you actually have the defense attorneys for a client trying to turn the client in the direction that the state wants, that's as bad as it gets. So in essence, Brendan Dassey never actually had, at early stage, proper legal representation.
Does anyone know if Kaczynski had represented any other minors? Like I don't know, within the last 5 years of him representing Brendan?
He wasn't a regular lawyer. He was a judge or something, right? And they moved him.
I think he lost. I think he lost the election. And he became a defense attorney again, and then a public defender, I guess. Really.
So he was a judge before he got Brendan's case.
Yeah, but like a traffic judge, he didn't really deal with anything. He wasn't like a circuit court judge like Judge Angie or any of the other ones. He was a.
Well, my point in asking is, so basically he had absolutely no experience with children and juveniles.
Not to my knowledge. I don't know of any other cases, Nosy, but I can't say that for positive.
Okay.
As far as I know, no one's ever really.
Maybe he should be given a colonoscopy and looked at. Much better.
I have a question here.
Yeah, go ahead.
T1, is there currently a petition or movement viewers can get behind on removing qualified immunity or absolute immunity?
No, not that I've seen, and I researched it too.
But we could sure use one.
Yeah, we definitely need one because there are so many camps out there, like Julius Jones camp, Rodney Reed camp, all Ahmaud Arbery, George Floyd, all these cases out there that have an army of people that could definitely blow up a petition like that.
Yeah, we definitely need
We
a
need
champion
somebody
to take
good
that.
at writing.
We need Henberry to write us a petition.
Yeah, we need somebody good at writing petitions.
I'm good at writing, but not it. I cuss too much.
Well, we could go back and take out your cuss words and switch them with more creative.
I did remember seeing
Paint a prettier picture.
Before we move on, I did see a comment from Paul Ward. Would like to see a list of all the wrongdoings in this case. Planted blood, bullet, press conference, the note, false confession, O'Kelly, the coroner. And he still hasn't named everything.
It would be easier to put together a list of what wasn't wrongdoing in it.
Just think about all the dispatch calls that we didn't get. I feel strongly that many of the dispatch calls and the CASO dispatch calls that Seeking Truth got, I think they were screwed with, and because conversations were cut off, people would come into conversations that you could tell that there had been a previous conversation going, but you didn't get the front end of it. It's crazy. The flower video.
Yep.
Some of the jailhouse calls we can't even get. There's like 3 or 4 of them that we can't.
I'm gonna get to that.
Oh, okay. Because I was about to ask why.
Yeah, I'm gonna get to that.
Okay.
Yours, you have a comment for him before we move forward?
No, go for it.
Oh, okay. All right. I thought I heard you say something. Okay. So we could spend a lot of time on this subject alone, and I knew it when I selected it. But The next part of this, in going into these cases, this case is the ability to write a FOIA request. And, it's not as difficult as you think in most cases. There are some that can get complicated. They are. And I've been through a few that I've been into some pretty significant back and forth, via email with people involved in the law enforcement technicians and so forth, trying to get what I know exists and them saying, no, it doesn't. But sometime back, let's see here how long this has been up. It looks like December 21st, 2019, Henbury, hats off to this guy. And he actually dedicated this topic to me. I don't know why he did. I really appreciate him doing that. It was unnecessary. I mean, I just try to help where I can. But, he wrote this Know Your FOIA request in an effort to get everyday people, to think about the case, something that's bothering them that they cannot find an answer to, and submit a request. It costs nothing to submit a request. And even if you get an approval for a request, that doesn't mean you have to actually go through and get it. That's because it's a multi-part stage. And we're going to go through this a little bit. And what I did, I took excerpts. Let me pull some up. Let me get this going here. It's not this post is not a really super long one, but it's long enough that he really does explain in detail. Let's see if this is it. No, that's not it. Yeah, this is it. He goes into some pretty good detail in how to do this and do it properly, so it's not so difficult. And I'm not going to read everything that I've got that I put up here, but it will give everyone an idea of what to do and what to expect. And those out there that haven't done it, if you need help, help's available. I mean, I'm willing to help someone if they're looking to write a FOIA and they're a little concerned about their verbiage or whatever. I'll be glad to help you. But this kind of explains what to do. He looks at this as a kind of a journey, and it's a good way to look at it. And he says, rather than provide an account of my own grievances with theft and passengers who are complain about the free information obtained and paid for by someone else for the benefit of everyone, I thought it best instead to provide an account of my own experience and requesting information, and therefore provide a guide to everyone on how to request information themselves. If we all learn how to request information confidently, then we can all help each other and hopefully unearth some hidden gems, enhancing everyone's understanding of this case, and more importantly, enhance the likelihood of righting the wrong in this case. And he goes on to say, anyone in the world can request information. You're not barred just because you live, where yours lives, and because he's clearly written some, and it doesn't matter. You're free to request. Now, there are ways to request anonymously because people don't want their name on some list somewhere that, they don't. I understand. They feel like they want to be private. Hey, that's okay with me. I haven't gone that route, and many people haven't. They want the information, and they give their their name and email and so forth, and that's fine. I don't have a problem personally, but some people do. There are ways to do it. I can't fully instruct you on how to do that, but there are ways around it. So, generally you don't have anything to lose. And this is one of the major points in when he wrote this. I'll read a little bit of this, maybe this right here. Before continuing, I must say from the outset that unfortunately requesting records under FOIA is a game, and he is correct. And I'll get into a little bit of that. As you make more requests, you get better at learning the rules and the ways around them. Do not be afraid of a denial, because denials help you learn more about an agency, what they're holding, and what tricks they'll employ to prevent disclosing information to you. Do not be deterred. I strongly encourage everyone to pick an aspect of a case that interests them, consider who might be holding more information about the aspect, and how you might be able to extract that information from them. And this is a really good point. Don't be afraid to write a FOIA. You may get denied. And again, you might get approved. And we'll talk about a little bit more about that. What is the FOIA open records request law in Wisconsin? Now, I'm going to say, because we talked about this yesterday, I think, I don't remember who looked it up, but the open records request really started in the federal level in the late 60s, if I'm remembering right, because we were talking about it. And then this spread to the state level.
Yeah, 67, I think.
Yeah.
Yeah.
Was it you that looked it up, BB?
Yeah. It was. Yeah. It started in the federal government in 67.
And then that filtered down to the states, and most states have their own version of the open records request, and they all have their own little nuances and so forth, but they're all basically the same. You can't get everything. There are some things that are not legally available through open records, but there are things that we can get that may not necessarily have been, presented front and center at a trial, i.e. the DCI reports. We know that many were included. The agency probably, yours could probably answer this one better than I, but I think there were probably roughly 50 DCI agents involved in one way or another. Does that sound about right, yours?
Yeah, that's about right.
Yeah. So, all of these agents writing these, somebody's echoing. Oh, there we go. All these agents submitted some type of report, and we've seen some. But when Zellner was writing her briefs and so forth, and so maybe we get tidbits here and tidbits there. We'd even get some reports that were maybe the report was 4 or 5 pages, and we'd get a couple of them. So that was of interest, and I'm sure that there's still more things that like DCI chain of custody records and ledgers. We don't have those, and that would be of great interest to me. There are photographs we still can't get that are of great interest to the public. So he goes into the definition and of the Wisconsin Open Records Law. I'm not going to read it. This post is available. I think I gave the link to Kat and to Linda if they would please post that. So people that have interest can go and check this post out, this topic, if they feel the urge to write. And who can I request records from? And he goes into, and all these places are named off: MTSO, Calumet, the Department of Justice, which is basically the DCI, and then beyond that, the crime lab, which would get filtered through the DCI, the Department of Justice, because it's a reporting agency to the DCI. They're connected. Wisconsin State Troopers, there have been several requests made through them. Yours, I think you made the request for the Grand Chute photos. Does that sound right? You got the
yeah, that's right. Yeah.
And then ODOG got some more open records, some more photos through open records. So take it from that. They can be done. There's things that can be shared that gives us a greater understanding of the case as a whole, which is really what we're after. Then beyond that, you get up to the FBI level, which I've never written a FOIA to the FBI, but they have their own set of rules that they have published, and some of them I tell you are, well, I'm not going to get into it, but they're.
Well, hey Jax, I've got an FBI friend actually that I've known for quite some time. So really? I could have him send me some, like a link or something to show how you would request at a federal level.
That would be helpful.
Okay, I will talk to him about that.
Well,
I never thought about FOIA at a federal level though.
Sure. Well, in this case, and yours and Doc can speak to this if they wish. This case is connected to the FBI because of the bones that got sent to the FBI for testing, the blood with Dr. LeBoob, as we call him.
Yeah, true.
Dr. LeBeau, which, again, there's this connection there to them. I don't know of anyone really that's FOIA'd too much or really anything that of interest, but that doesn't mean they haven't. I don't know. I really haven't seen anything. So maybe they have, and maybe they haven't. So anyway, in this link, these are all, I've got it greened up here. This is just a snip. So, but all these are links, and it shows you who to request. It's got the actual email address that you can, copy and paste or get into your, Gmail or whatever mail apparatus you use to make your request. And then how do I request records? This is a pretty good read, and he goes into some detail, more detail. It's always helpful when you're writing a request to have some reference somewhere in a legal document, i.e. the CASO investigative report, a court transcript, a pretrial, something that gives you a segue to say, hey, this was mentioned here, and you can even cite the page or put it on as an attachment, and it's a direct reference. Keyword, he talked about it being a game. Using the proper words are key in some of these requests, because if they look at your words and they can manipulate the meaning on their end, which is not what you meant at all. I got into this big rigmarole with in this aspect. So wording and keywords is vital in making these requests out. Be polite, be professional. Don't call names and say you bastards. I know you got it. Don't do that. Remain civil. We're trying to be straight and non-hypocritical. So we're looking for the truth. In closing statements, you don't have to really say, I want this because, I think that Officer X is a lying son of a bitch. And you don't need to do that at all. You don't have to tell them why you want it. You just want it. It's public record. And, if they're looking for transparency, that's enough. So some places do require signature. But as far as I know, in Wisconsin, again, you can request anonymously. I've never tried that. I know others have. And then what happens after the request? I just went through this, like I told you guys. There was a CASO request, and it was through email. They answered it immediately. And from my end of it, that's the resolve of this particular request. Now, that doesn't mean there won't be something. I've actually sent a request back, or a reply back to the person that answered me, requesting more information about the length of retention dates. How long do you keep stuff? And based on that reply, I may have more questions or another request. So we'll see where that goes. So they'll get it. They'll reply to you. Generally, a lot of times you'll just get a form letter back that they've got your request and they're looking into it. Sometimes you don't really get anything. My advice to you, give them 10 days. After 10 days, if you've not heard anything, send another email requesting, and be sure to reference your first email. This date, curious as to how this is going. Do you have a time frame? Thank you. Move on, send it, and see what you get. That way you have a record. You're not really pestering the hell out of them, but 10 days is enough to get some kind of reply back to any of these agencies, I think. Anyway, I've got 3 other requests out there hanging right now that I've got a little bit of feedback, but I haven't gotten an answer. So we'll see where that heads. If the agency considers your request can be fulfilled, they will provide you a cost to copy paste the records and may request you prefer delivery method if you have not yet provided one. As an example, CASO uses a simple online credit card payment system. Once you've paid, email decision maker with a copy of proof of payment of the payment number. Once proof of payment is received, the agency will release the records to you. Payment can be made over the phone via credit card, and there are other ways. But we've gotten records from Manitowoc County through the contact there, not Larry, but another one, to get court records through Barbara Parent, and she's extremely efficient. She's excellent to deal with. She's so nice and so helpful. But other agencies are not as helpful and just downright rude. So it just depends on. I understand. These people have been hounded. I get it. At the same time, they're in that job for a reason. That's what they get paid to do. So the bias stigma is there, but nonetheless, we have a right to request. What do I do if my request is approved? I want to get into this a little bit here, and I hope everybody that's listening heeds my advice, because I've been through this. Because as you saw a minute ago, my account was permabanned. What do I do if I would get my request is approved? Share your documents on TikTok Manitowoc. I'm advising you now not to do that. Do not share. I'm actually going to talk to Henbury about removing that because it's been about 3 weeks ago now. I wrote a topic on TikTok, and it was about the RAV4, and it was concerning DCI Report 167, and I think there was another one that may have been involved, but I didn't include the entire report. There were only sections. There was no personal information shared, but the only information that it could even be closed to be personal would be the agent's name, which was Steve Harrington. He's a DCI agent or analyst, whatever, at the crime lab, and that's no secret. They're public figure. I mean, I didn't consider them anything other than a public figure, but it was just a name. It wasn't an email address to their house or nothing else. Anyway, apparently it got reported, and I was permabanned immediately, and the post was removed. So I'm advising there are other people. Yours has been through this with even less information being shared. It came from a CASO report. Basically the same thing, right?
Yeah, same. Well, another report, but also sharing, names that I thought that we are, public, but they were not. So.
And there's another place where people could share their FOIA information, right, Jack?
The library.
And Discord FOIA.
That's right. Yeah. Yes. Yes. Did you get a link to the FOIA server?
Yes,
an invite. Yeah. Thank you very much for doing that. I appreciate that. Yeah, you can share them on the FOIA server. Many people from all over, are in that. The thing is with FOIAs, there's this thing started some good long time back, and I really wish it wouldn't have. But there became this competitive nature about being the first to get a FOIA. And, if we were in a marathon, I would say, okay, great. We're not. This is a different, I see this as a different thing. We're trying to get information out for everyone instead of hoarding the information and not sharing. It also saves cost, because, some of these are not really that expensive at all. But, why pay more money for something that you've gotten that you want to share? Again, you can't, I can't bitch and gripe at someone that doesn't want to share their FOIA because they paid for it. At the same time, if they're using that information out in the world, why not share it with the rest, at least the people in the FOIA server that can be then disseminated to other places that say, hey, somebody's already FOIA'd that. We don't need to write. Let's not go after that. We already got it. It's pointless. It's like the crowdsource that we did, in January, February of 2016. Can you imagine if we had just hoarded that? It's self-defeating, because we're not talking about a race. We're talking about, people's lives. So it would be great, if people would utilize that, and to some degree people were. But there's that other aspect. So, we'll just deal with it the best we can. If you want to share, it's there. If you don't want to share, then, that's your business too. I'm not going to, you paid for it. If you don't want to share it, more power to you. That's fine. So, anyway, once it does get shared, it's really up to the person whether they want to share the information out in the world. As we found out, Zellner was not aware of certain things, that information got sent to her, and it's just like, well, wait, I don't have that. again, the records are considered public property, and generally there's no restriction. Again, I would just advise anyone on Reddit that's hearing my voice now, until some other changes or whatever decisions are made within Reddit, I wouldn't share anything on there, because you're risking a guilty reporting you and you getting a perma ban. Bam, just gone. I was shocked when it happened to me. I'm sure yours was as well. There were emails. Well, there were emails that were shared on Reddit. All the private information was redacted, and that person was banned, and all the posts were removed. So there was some interesting information in those too. But they're in the library. They're a foul play library, so people can still go and read them. They're available. We have no restriction there. So share away.
We just need to add whoever owns that site to the freaking list with Jack Dorsey. Take them all out.
What's that, Nosy?
Banning people for freaking freedom of speech. Shit gets on my nerves. I'm on like account number 75 now at this point. So.
Well, that's okay. You speak your mind, and it's amazing, what happens, when someone speaks their mind and can rattle the cage a little bit, what falls out. So anyway, what do I do if my request is denied? Read the denial carefully. The decision maker is required to provide you with the truth about how to proceed if you are not satisfied with their decision. If the decision maker has offered an invitation for you to respond further, then you should respond. The alternative is usually to escalate the denial to the DOJ. And there are different levels, if you get denied. Again, wording, go back to wording, go back to a source, something that you can latch onto to say, hey, this is mentioned here. I'm requesting because it's not, so wording is key. Don't get discouraged if they say, oh, no, can't have it. No, because of X, Y, and Z. I'm going to get briefly into exactly what BB brought up a minute ago. And these are I think it was BB, whoever said it, or Linda, these 3 or 4 calls that are late October, early November 2005 that we can't get. Now, we have about 1,380 jail calls between Avery and Jody and so many other people. Yet these 3 or 4 calls, Sheriff Wiegert has denied because he says that his first response was they're sealed. So we're all thinking, well, holy shit, a judge has sealed those calls for some reason. But that didn't make any sense because Judge Willis ordered everything unsealed in his third order. It's in the Stephen Avery case. I think we've got it too, but StephenAveryCase.org. He unsealed everything that was already, but that was still sealed into the public. So we're thinking, well, okay, there's got to be a record, So somebody inquired, well, I'd like to see the judge's order that sealed these records. And of course, he had to give it up and say, well, it's sealed with evidence tape, and I'm not cutting it. So they're sealed, but it wasn't a judge's seal. It's evidence tape. This also questions all these other over 1,000 calls. They weren't sealed too. So there's really some strange questions here that I know that this has probably been escalated, but we'll see. It's really strange that these 3 or 4 calls are not released. That's another argument that I've been into on Reddit. I don't know if I'll continue it or not, but whatever. Okay, that's it. It goes back to the video. That was the last one. So I've been running my mouth here for 15 minutes. So questions, comments, concerns about the FOIA process?
Kevin has a question. He said about going to the courthouse and getting them yourself, picking up a FOIA there.
Yes.
I said to him, yeah, you can, but you still could be denied, correct? I mean, you just know why right away.
Yeah, I mean, you still have to submit a request, and if they deny you, I mean, you have to submit it before you go to the courthouse. If they deny you, through the phone or whatever, then no, you can't have it. If they approve it and you live in that area, yeah, you could go pick it up if you wanted, pay for it, and be done with it. Absolutely.
You just can't walk into the courthouse and ask them to see records or nothing.
I think it varies by state. I'm not gonna say for sure, but I think it varies by state.
You can hear where I'm at, because I told y'all for the Danita case, we have at our big main courthouse downtown, you go up to the second floor and it's the records floor, and you walk in and you literally just sit down at a computer, a little cubicle, and you can literally research anything under the sun that has ever happened since my county has been alive.
Yeah, I could do that here in Minnesota too.
But if you want to print, then that's where it costs money. But just to go look up the information,
right?
Yeah, you can just walk in and do that.
What about audio files and that type of thing, Dassey? Same thing?
I don't know about audio files because I've never actually looked at any type of audio files.
I'm talking about dispatch recordings and that kind of thing.
I don't know. I'm gonna find out on Monday when I go down there, though. Now that you say that, but no, I've always just gone to look at dockets, court proceedings, transcripts, and stuff like that.
Right.
I'll let y'all know though.
Interesting. Well, this we can talk about Manitowoc Dispatch recordings, November 4th, 2005. Nothing.
No, that's a good one to get.
Yeah, I'd like to shout out Hanbury, who's out here. So Hanbury, out of right up.
Yeah.
So you can you have what it takes, kind of thing,
If you want to know what's out there to be FOIA'd, that's really a hard question to answer. There's such a lot, and well, the best advice I would give is just ask around, because there's a lot of stuff to be FOIA'd, and there's also what has already been FOIA'd. So I've been FOIAing stuff that's already been FOIA'd, and I think other people have as well. So there has to be some kind of system that's oh yeah, there. Well, I know that foul play has that system going on. There's some kind of way to check what's already been FOIA'd, but I would advise to ask people around and really check on what's already there and what is wished for from the community.
I agree. One of the goals that we have is to create, and I think we've already really surpassed it, the largest library out there, at one place, exactly. a one-stop shop. And I know that you were working on, or are going to be working on, getting the photos keyword tagged so they're searchable, which will be
that's one of the goals. But yeah, the other goal would be what would be out there to get for us and what's already been taken, so we're not doing double work.
Agreed.
Double work is a big issue in the community for me.
Yeah, it is
all the time. Shit. Oh, you ask the same question, and FOIA the same documents that already have been. I mean, if you're new to this case and you don't know anything, you probably do that.
Absolutely, I agree with you 100%.
And it's a waste of energy and money.
Yeah,
that could go into other FOIAs.
Yeah.
Well, that's another thing. Once if you get a FOIA that's approved and you get that information, that can definitely lead to another FOIA because you found out something that, okay, and it's happened before. I will say that a couple of things. Back early in late February, early March 2016, when all this was breaking loose and it was crazy town, there were emails that were flying between the DCI and Calumet and I'm sure Manitowoc, about what to release. And, there were the DCI made basically a strong decision right then. We're not releasing anything, which I think really is, to me, it just goes against everything the open records is, because they've closed everything. It's like, nope, can't have it. Nope, can't have it. And at the time, there was, there could have been pending litigation, but at the time, Zellner had just taken the case. So I don't know. I just think it was, what's going to change if they release something that we haven't necessarily seen elsewhere? Nothing, because the report, unless they're going to go back and change some reports, which I don't think they can actually do, it is what it is. So.
Yeah, exactly. Well, DCI is as close as a rock, and well, when we got the DCI records, it was basically because we changed the verbiage. We said like we want agency copies, agency copies yes. of case reports, of DCI reports. So it's not literally like direct going to the DCI; it's just going to CASO.
That's right. That's why I said a minute ago, keywords or verbiage is so important.
Yeah. Yeah, it's very important to try and, change your verbiage into something else, try to get it another way, because, they're really sensitive to it. They might bite, they say, oh, okay, yeah, that's right. Yeah, give it to you.
Right. Well,
Kelly asked if those calls from Jody and Steve are sealed. Does that mean Kathleen Zellner wouldn't have been given it because it hasn't been opened?
Well, those calls, I think they are already in the possession of Kathleen.
Yeah.
Because there's actually a CD that Reamer took from, I think it's item 7828 or something, that has all the calls.
There's nothing sealed by a judge, correct?
No.
Right. So they just mean sealed by tape, and they don't want to open it. Too fragile, this, that, whatever their excuse is. Doesn't really mean you can't keep asking for it, correct?
Typically speaking, when a lawyer, a FOIA requests information and then they get it, that opens the door for the public, typically speaking.
Well, Shores was saying he thinks that Zellner might have it because of a CD, right?
Yeah. Well, the DCI...
So can't we FOIA that CD and get those for...
Yeah, that's a good question. No.
On it.
Don't forget that one, yours, because we need to go after that one.
No, but well, it's in the discovery report, and that's why I assume that Zellner has it, and she has it's 4 calls, 1, 2, 3, 4 November.
Okay.
So, yeah, I think she has it.
Well, it would be interesting. I mean, I just it's a real head scratch for me. There may not be anything on there at all that they're talking about.
Yeah.
There has to be.
Well, I mean, it raises the questions. We've got all almost 1,400 calls. Were they not sealed too? and all of a sudden we've got these 3 or 4 calls that are sealed, and he won't break it. It begs the question.
I think we should try and get that CD.
I agree. CDs were generally like $5 or something other. So.
Yeah, they have been played before, but they are denied.
Yeah.
So yeah.
Okay. Well, we're coming up on 3 hours, and I've talked a lot, and I want to thank everyone for their patience. I've tried to just impart some knowledge. The surveillance part of it, it really hackles me. Just grinds my damn gears bad. The FOIA part, it really kind of hackles me too. I'm not, I'm not a FOIA guru like, Yora's and Rookie and Seeking Truth and, many others that have really spent a lot of time and have gotten so much information. Personally, I can't thank them enough. I know they don't really want thanks, but it's there anyway. And, I always try to credit people, that have gotten this information. If Kat and and Linda would please, repost the links to the FOIA, or to the FOIA, how to FOIA topic on Reddit, and then of course to Seeking Truth video that she got, the FOIA. That's another thing about that 5-minute video. There's no way that's all of it. So why do we only get 5 minutes? I can't answer that. I can't answer that question, but I just thought it was kind of strange that there wasn't someone coming in, showing Avery coming in and so forth. It was just a 5-minute video and that's it. I found that a little deceiving on their part. I think there's far more to it. I want to thank our mods for continuing putting these links up and stuff and keeping the public informed. Misinformation is a killer, and I've spent so much time. I know yours has, and other people. We try to put out correct information, and that was another part of my purpose in presenting the surveillance stuff and showing how the process is supposed to work. It's actually much more in depth than that. I only skimmed the top. Linda will tell you, because we kind of got into the reporter end of it as well. If you remember when we did that.
I'm a little bit more pissed off than I was then hearing this stuff.
I thought you would be. It sinks in a little further. After you hear it the second time, it's like,
I think it's very important. I really do. It's just a total violation of his right to have a counsel and, have privacy to discuss his case. You might as well have the state right there with him. Come on.
Well, that was another argument that I got into. I think it was, I don't remember which one it was. I said, what's the point? Please explain to me the point of having privacy rooms where the defendant is recorded with his lawyer, or his lawyer just picking up the phone through the barrier and talking to him there. What is the difference? Why have him at all? Or a priest or a drug counselor or anyone else. If you're just going to record him anyway, what's the point? Because it's serendipitously, or I don't have the right word. I can't pronounce it correctly. Because they didn't have anything marked in that room that they're saying, hey, we're making a recording here at all.
That's right. It's unlawful all the way around. You can't record me without me knowing it and use it. That's illegal. So, where does it stand there?
You can where I am.
Yeah, I know you can. In Texas, you can do a lot of things nowadays.
Can you really, Nosy? You can record secretly there?
I can record anybody I want to. It's a one-party state.
Ooh, damn.
Yeah, y'all see why I'm sneaky now?
Well, that can open up a lot of avenues there. But anyway,
especially for the cases I look at here.
Anyway, we're like I said, we're approaching 3 hours, and I'm conscious of everyone's time, and appreciate everyone hanging in there. We've got a lot of loyal people out there. If anyone has any questions, I'll try to answer them if I can. If you want to, jump onto Discord or whatever, and I'm on Twitter as well, and the other people are too, that are available to, help answer questions more about the case. Again, if you want the case, this older case file, let me know. I'll talk with. I'm sure Seeking won't care if we share it. If there's anything else burning that anyone wants to get off their chest before we go, Doc? Anybody?
No, I'm all good. The only comment I want to make is it's probably the 5% of the information that is being withheld that will bust open the case, and that the state are protecting it at all costs.
100% agree.
Yeah, I'd have to agree with that.
Yep, totally.
It's a very, very small percentage, and
correct, a small percentage, and that information will be privileged information, and the state is not going to give it up.
Okay, next week, I think Dr. Silkman is going to have a good round of questioning with Dr. Lean We'll get the date and times set up for everybody so they can join in. I think it'll be a really, really interesting conversation. Time changes for Dr. Silkman next week, so I'm not going to even. I'm not even going to try to put out a time frame right now because I will get it wrong.
Yeah. So the whole idea is that hopefully we can get Dr. Sandra Lean to come on and do a live chat with us. But we have to organize, like you said, a suitable time where everyone's awake.
Yes. Yeah. I
think it's penciled in for 7:30 a.m. Central Time.
Tentatively speaking, that's correct. Sunday morning for us. That would be, God, I don't even know what time it would be for Doc.
Probably nighttime, I would say.
Yeah, probably like 9. Probably like 9 or 10.
I think it's 10 p.m. Yeah.
That sounds about right. Yeah. But we'll get those plans firmed up and get an announcement out. I'm sure Zoe will be working on it.
Once it's firmed up, I'll let Sandra know, and we can get something organized. That'd be awesome.
Excellent. All right. I want to thank everybody one more time, and this has been a Foul Play production.